In respect of item number 62, my lord, I have the instruction to issue this report.
Item number?
62.
Hmm.
I have the instruction to issue this.
Mr. I. Soikia, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the writ petition. Accordingly, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
But item number 16, I will take instruction from my client whether he wants to pursue this petition or not, my lord.
Item number 16.
16, my lord.
Yes.
But, he is not in service. I will have to take instruction whether it will he wants to pursue this review petition or not, my lord. Lord, will take up this matter, my lord, in the next day.
He is no longer in service.
He is not.
Whether he wants to proceed with the review or not. Mr. I. Soikia, the learned counsel appearing on behalf of the petitioner submits that the petitioner is no longer in service, and as such, the petitioner would like to, and he would like to obtain instructions from the petitioner as to whether the petitioner would like to proceed with the review application. Considering the above, list this matter again on 11th of February 2026.
Another man, but where this petition was fixed on, my lord, today.
Which one?
Just for matter, my lord, for admission. This was fixed for listing.
Admission.
My lord. It was fixed for today, my lord. It has not been listed. Can it taken up?
It was fixed by me today.
No, my lord, by honorable Mr. Das Cake of some matter. It was Wednesday matter, my lord.
Okay.
Tomorrow or day after tomorrow, my lord.
6th.
May I please, Lordship, a casual, my lord, the employee of the Guapa MSCT Court, despite submitted representation for regulation extension, my lord. Nothing has been considered in between, my lord, advertisement published for filling of the 4 posts, my lord. No, my lord, his time is now my lord, going over, my lord. Lordship, I pray this matter, can it take a day after tomorrow, my lord?
For admission?
No, my lord, fresh matter.
For motion, matter. Day after.
May it please your lordship, in item number 47, your lordship. Item number 47, I have filed my affidavit in opposition, your lordship, for respondent number 5, but this has not been brought on record, your lordship. Lordship may permit me to bring it on record.
It will call up. It will
Lordship.
call up.
Obliged.
For listing, my motion matter on day after tomorrow.
May I please, your lordship, I beg to mention for listing one writ petition next Friday, lordship.
For
Admission matter, lordship. Lordship, petitioner is a service holder, lordship, ASHA worker. But the respondent authority illegally removed from his service, lordship.
she has been removed from service.
Yes, lordship.
So what is the urgency? We'll have it on 11th.
Deeply obliged.
Lordship, mention for listing of fresh motion matter tomorrow.
Now, why tomorrow?
Urgency.
What is the urgency?
Transfer matter, your lordship.
Today?
Then the day after tomorrow.
Today?
Today, sir.
May I please, your lordship, I beg to mention listing of a writ petition for admission. The date of last posting on 1/12/2025, but it was not listed till it. Kindly matter be listed on day after to.
13th.
May I please, your lordship?
30.
Lordship, I beg to mention 3 petitions for listing lordship under motion column lordship. Day after tomorrow, lordship. May I please, your lordship? Lordship, I beg to mention for listing of an contempt petition lordship.
Okay, 13th.
May it please your lordship, I beg to mention item number 63. It's for orders, your lordship. May I pray for it to be taken up at 2, your lordship, or any time before your lordship rises.
Why?
Your lordship, because it's a transfer matter and there's no stay operating on it, your lordship. It was only for instructions today, if the instructions have been brought or not.
We'll take it up at the time of immediately after the motions.
Yes, your lordship.
May
Obliged.
please, your lordship, I beg to mention writ petition for motion, your lordship.
May I please? I beg to mention listing for a writ petition on motion. Yeah, that's it.
I feel the basic. I pray for listing of a matter for admission, lordship, relating to pension, non-payment of pensionary benefits, lordship. Can it be in that tomorrow, lordship?
6th.
6th, lordship. Obliged, lordship.
Please, your lordship, I'd like to mention item number 2. Planting the matter may be taken within 3 weeks due to the senior not being within station. He's out of state.
Why?
For medical treatment, he has gone. Planting the matter be taken in.
We'll see when the matter reaches.
They have to for listing of an application tomorrow.
Why?
Tomorrow or day after tomorrow.
Day after,
Listing of a,
One for withdrawal.
day after.
listing of a fresh motion matter, when is
Yeah.
it?
Lordship, I think instruction to withdraw this petition minor. However, the petitioner wants to file a fresh minor for his pension claim minor.
You want to withdraw?
Yes, minor. With the liberty to file a fresh.
What liberty? No liberty. Liberty, then it's a different thing. Why do you want the liberty? Give me a good reason.
But the petitioner want to claim his pension minor.
Huh?
Petitioner want to claim his pension minor, for pension and pensionary benefit. And this writ petition has been filed against the discharge order for the prayer of the reinstatement.
Then,
Now he changed his stand and wants to file a fresh for pensionary matter, for pension purpose.
that's a different cause of action. This is a different cause of action. Here you are challenging the
Discharge order.
discharge order. So you are not, you have no problem with the discharge order.
No.
Mr. V. Kumar, learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. He however submits that the withdrawal of the instant writ petition should not preclude the petitioner to file a fresh writ petition claiming pensionary benefits. Taking into account the above, the instant writ petition is filed challenging the discharge order. The discharge order and the claim for discharge, the challenge to the discharge order and the claim for pensionary benefits being separate, the withdrawal of the instant writ petition shall not preclude the petitioner to avail such remedies. Accordingly, the instant writ petition stands closed on withdrawal without prejudice to the petitioner's rights to file a fresh writ petition claiming pensionary benefits if so permissible under law.
Might please lordship.
What is your case?
My lord, the petitioner was a driver, your lordship.
Hmm.
He was the driver of Moirawari Fire and Emergency Service Station, your lordship.
Hmm.
Appointed, your lordship, on 26/11 and 2010, your lordship. That is at page 11, your lordship. What happens is that, your lordship, based on some personal discord, your lordship, between the wife and the husband, your lordship. Because the 498 case affair was lost, your lordship. And subsequently, when the trial commenced, your lordship, and outside of the court, it was, your lordship, settled between the parties. And accordingly, I have been acquitted, your lordship. But the thing is that, your lordship, based on this personal discord, your lordship, page 18 may kindly be looked into, your lordship. Stoppage of 2 months annual increment, that is page 18, your lordship.
This is against the disciplinary process.
Yes, your lordship.
This is
This
the,
is
what
against
is,
the
what is the
disciplinary
basis on which you are
Because the
challenging
reply-
that?
Reply was not satisfied, your lordship. And accordingly, your lordship, two annual increments were stopped, your lordship.
Now, what is your case?
So my case is lordship. Subsequently, I have filed an additional affidavit, your lordship. Two representation was filed because earlier I could not, your lordship, and subsequently, three representatives were given, your lordship. And subsequently, page 31 to 49, your lordship, I can look at, your lordship. Only based on the sole testimony of the wife of the this. The inquiry officer was submitted a report, your lordship. So, right from 2010, your lordship, So punishment, stoppage of two engine increment was, orders passed on, your lordship, 2024, your lordship. Within 8 years of my service career, lordship, I have never taken. So,
No, your allegation is
look,
as regards
Ah,
unauthorized absence.
yes,
Why you are bringing into your wife?
because your lordship, 3 days, CL was earlier granted, your lordship. 3 days CL was earlier granted, your lordship. So thereafter, because of my illness, your lordship. So, total 90, after 93 days, your lordship, I arrived for the office and reported, your lordship, and in between, your lordship. Representation were all, not by myself, from my brother, your lordship. That is indicated in the, your lordship. Page 34 may kindly be looked into, lordship, recording a statement of PWs. May I read you, lordship? On recording the statement of Pratap Chandra Kalita, it stated that his station driver Ariful Hussain had proceeded to his home on 1/2017 morning on permission for Eid festival. On his return from home on 4/9/2017, the delinquent driver requested to avail 3 days scheduled leave for his domestic affairs, and as such on 4/9/2017 PM, the driver was allowed to avail 3 days CL, which was already granted. On 6/9/2017, he received the WT message from OC before he had PS that a case being 328 oblique.
Mr. Goswami, tell me, on one hand, what is his allegation? Let's see the statement of allegation,
Yes,
page
Lordship.
33.
Lordship.
While you were posted at so-and-so, a letter of complaint against you has been received from your wife. She has stated in the letter that after marriage, you have ill-treated her quite often for dowry and also on date, and you have a conspiracy to murder her by feeding pesticide mixed juice. In this regard, a case has been registered. On the other hand, you have been remained unauthorized absent from duty with effect from here till date without any leave or permission. Till date, what is the
Yeah.
date? So cause notice dated?
Because notice dated, you lordship, it's on. Lordship,
So,
page 32, your lordship.
Date?
Page
32.
32 show cause notice. It's the first show cause notice.
What is the date of this document?
It's 21/10/17, Lordship.
Huh?
It's Soko's Lordship, first Soko's notice, Lordship, as per my records, Lordship. Soko's notice that is 21/10/2017, Lordship.
Okay, so he has been absent from 8/9/2017 to
Yes, Lordship.
21/10.
Till date, Lordship.
So that is the date
Yes, Lordship.
when you have issued the show cause notice, the
Lord-
statement of allegation.
Lordship.
So he was absent for that.
Lordship.
Okay. Now, what is the allegation against him?
Lordship.
What is the allegation against him?
Allegation, Lordship, first of all, regarding the criminal case, Lord, the facts of the criminal
No, if
case.
there is a criminal case
Lordship.
filed against him by his wife,
Lordship. That is,
then in that regard, a disciplinary proceedings can be initiated.
Lordship, in the same time, Lordship, unauthorized absence.
So therefore, the
Yes.
question is of unauthorized leave.
Lordship.
Now let's see the inquiry report, which is
Yes.
given at page 35. Page 35. In course of the inquiry, the statement of the delinquent heirs was also recorded in separate sheet. In his statement, it appears that while he was being involved after marriage with so-and-so parallelly, he had taken advice of Dr. So-and-so. As such, he sent his brother with an application along with prescription so-and-so. Leave from his duty after 90 days in 93 days. Therefore, I'm not understanding how is it possible?
In the,
And what is he guilty of? Where is the finding?
yes, finding lordship, it is in
Page 35.
page 35.
On
lordship,
the above
last-
discussion, I come to that the charge is framed against him. What is the charge framed against him? That there is a case against him. Or is it the charge that he has been, he was involved in some criminal conspiracy against to kill his wife? Or is it the case of the leave? Where is the finding? And why is the petitioner asking, did you, at the time of issuance of, after the inquiry, did you provide him the inquiry
No.
report?
That is lordship in that is lordship in paragraph 22 lordship,
Of,
in my affidavit lordship.
where do you say?
It is stated that after the DP findings, a
Hmm.
notice was served by so and so dated so and so so.
Where,
to the
where,
delinquent.
where?
It is page 22 lordship.
After the
Based-
notice was served to
Yes.
the delinquent to inform about the findings.
Yes,
The
Lordship.
question is, did you provide him the inquiry report?
Lordship, that's why lordship in my record, record lordship, it appears that after this after issuance of this second show cause lordship, this is second also regarding the findings lordship, he submitted a reply wherein he had not stated that he had not get the findings.
But he has
of the inquiry
submitted
report.
many representations for asking
This
for
is
that.
this is his first reply lordship,
Then second reply,
2018.
then the second reply.
No, this
Second notices, what do you say about these documents which you have enclosed along with this petition, an application for furnishing 22/1/2025? When did you get this inquiry report?
is 5/3 to 2018, lordship.
Mr.
Lordship.
Page 32, how did you get this document?
Lordship, it is the third time you lordship, because you lordship, three subsequent consecutive representations are given you lordship, submitted before the authority concerned you lordship. On so far the instruction derived you lordship on when the third replacement was submitted on 30/6/2025, then they furnished the inquiry report saying that they got it prepared earlier, but that day it has been furnished to us in the. So far the information there from the petitioner. is that.
So you got it on 36/2025.
Yes.
And your order is of 2018. How is it possible to impose punishment without giving him the so-called the inquiry report?
Lordship, on 05/03/2018, lordship, we asked him that to submit your reply after getting the findings.
Where is the document?
Yes, it is
First of all, why haven't you enclosed that?
that.
Why your petition, or is it that the state doesn't have the money to enclose?
Lordship,
No, no.
That-
Why will I look into it? You have not enclosed, so therefore we are not going to believe this. You have filed an affidavit without enclosing these documents.
that is my limitation.
Why?
That is my limitation.
We have not enclosed any of these documents. We have made various statements, but these are not supported by any documents. So therefore, on the basis, we are going to disregard all these things. And more particularly, when you say these to be matters of record and the record is not available,
The record may be called for lordship.
why should I call for? It is absolutely your fault.
Lordship, 19,
We set aside this.
lordship,
We set
1903.
aside this because of the inefficiency on the council or this person concerned who is hiding it. Who is it? Dr. Sadiq Ali Ahmed, Senior Superintendent.
Lordship, we may call for the record.
We set aside. No records have been called for. And to file additional affidavit, so and so, here, what is the order 26/6/2025?
Lordship,
Submit the inquiry was not furnished to him for which he had made an application and he is not inclined to issue notice. However, he is permitted to obtain instruction and appraise the court as well as to place the necessary documents so required as to whether the inquiry report conducted against the year was served upon the petitioner.
Lordship,
You have not done it.
no, Lordship, I have the documents.
Now you have the document, then let it remain out there. It will get what is the purpose? The only issue on which the petitioner has filed a writ petition is he was not provided the inquiry report. We
Lordship,
have not enclosed anything. And it is true that you did not provide the inquiry report. We set aside it.
no, may be allowed to submit the
And
reply
the
to the
inquiry report,
additional affidavit,
But
Lordship.
no, nothing doing.
May-
Inquiry report was not provided.
No, Lordship.
You provided the inquiry report on 36/2025.
In
And the inquiry report is also vague. Absolutely, it cannot be.
that
Now the inquiry report is there at page 32.
yes.
And it doesn't say anything that he was in unauthorized leave. So nothing remains. We set aside this. These type of things cannot be allowed. Where is the judgment? The inquiry report has to be given to you. Or you are also not prepared. Fantastic. Heard, Mr. What's your name?
Devan, Lordship.
A. Diwan, the learned counsel appearing on behalf of the petitioner. Mr. J.K. Goswami appears on behalf of the.
All the responsibilities.
You can't appear for the treasury officer.
Lordship.
That?
Lordship.
Appears on behalf of the respondent numbers 1 to 4. Mr. P.K. Nayak. P. Nayak appears on behalf of the respondent number 5. The present writ petition has been filed by the petitioner challenging the order dated 24/2018 passed by the Deputy Director, Fire and Emergency Services. That is the respondent number. Where? He is also not a party.
Lordship.
Mr. Counsel, only God can help you. You have not done your duty properly. You have not, the person who have issued this letter, you have not made him a party also. By the Deputy Director,
Fire and Emergency Service.
Fire and Emergency Services, Guwahati, whereby the petitioner was imposed the punishment of stoppage of 2 annual increment with cumulative effect in terms with Rule 7 of the Assam Services (Discipline and Appeal) Rules 1964. The case of the petitioner herein is that the petitioner was not provided the inquiry report, and as such, the petitioner was prejudiced. It is the further case of the petitioner that after requesting the respondent authorities on 3 occasions, only on 30/6/2025, the petitioner was provided the inquiry report. The said inquiry report, so provided to the petitioner on 30/6/2025, have been enclosed to the additional affidavit filed by the petitioner. As Annexure 2. Full stop. The question therefore arises is in the facts and circumstances of the case, whether this court is required to interfere with the impugned order. Full stop. The instant writ petition, though taken up at the stage of motion, but in view of various orders passed by the learned coordinate benches, the petitioner, the respondents, have already filed their affidavit. Full stop. The petitioner have also filed an additional affidavit pursuant to the leave granted by the learned coordinate bench in its order dated 21/7/2025. Full stop. Under such circumstances, this court therefore takes up the instant writ petition for disposal. Full stop. The materials on record and more particularly the inquiry report enclosed as Annexure 2 to the additional affidavit shows that departmental proceedings was initiated with the following allegations, which being relevant is reproduced herein under its statement of allegation বুলি এটা আছে, page 33. Put it. From a perusal of the above quoted statement of allegation, it appears that the allegation against the petitioner was that the petitioner had conspired to murder his wife by feeding pesticide. The allegation against the petitioner is that a letter of complaint was received from the wife of the petitioner that the petitioner had conspired to murder her by feeding pesticide mixed juice. And in that regard, a case was registered against the petitioner being Rupohi PS Nagaon District wide case number 469/2017 under section 498A/328/307. It was also alleged that the petitioner had remained an unauthorized absence from duty with effect from 8/9/2017 till the date without leave or permission from the competent authority. Full stop. This court have also perused the inquiry report wherein it was opined, inquiry report dated 22/2/2018, wherein it was opined that the petitioner was involved in a criminal case after marriage with his second wife, and he had taken advice of the Dr. Nagaon Civil Hospital. And he had sent his brother with an application along with doctor's prescription to the IC Moirabari FNES for extension of the leave and reported in his duty on 9/12/2017 after 93 days interval. The inquiry report further does not discuss anything more, but only holds that the charges framed against the petitioner as gross misconduct and indiscipline act being a member of the discipline force was proved beyond doubt. There is nothing in the inquiry report in terms with the charge made in the statement of allegations inasmuch as it is very pertinent to take note of that the show cause notice oblique the memorandum of charge was issued on when, Mr. Counsel, when? First show cause notice was issued on?
That is issued on Lordship, it is so cause. First so cause Lordship on 21. It is first of 21/10/2017.
21/10/2017. And the allegation was that the petitioner was in unauthorized leave from 8/9/2017 to 21/10/2017. On the other hand, the finding in the inquiry report appears to be based on something which is not there in the statement of allegations. Apart from that, this court also finds it very pertinent to take note of the decision of the learned court of the additional Chief Judicial Magistrate Nagaon, wherein it has been opined that the prosecution had failed to establish the guilt of the accused person, that is the petitioner, under section 498A of the Indian Penal Code. And the petitioner was found not guilty and he was acquitted. In respect to the same case, that is Rupohi PS case number 469/2017, this court also duly takes note of that though the petitioner was issued the second show cause notice after the inquiry report, but admittedly, the inquiry report was not provided to the petitioner, as would be very much apparent from the affidavit which have been filed by the respondents, wherein it is categorically mentioned that the petitioner was only informed about the contents of the inquiry report and issued the second show cause notice. The above aspects, therefore, clearly show that there was a gross violation to the principles of natural justice. And accordingly, the imposition of penalty by the impugned communication date order dated 24/2018 cannot be sustained in law. Accordingly, this court therefore sets aside the disposes of the instant writ petition with the following observations and directions. The order dated 24/2018 is set aside and quashed. Number 2, taking into account that the order dated 24/2018 is set aside and quashed, the petitioner would be entitled to all such benefits which the petitioner otherwise was entitled to, but was not granted in view of the impugned order dated 24/2018. Number 3, this court, however, grants the liberty to the state to issue a fresh, if so advised, to issue a fresh show cause notice to the petitioner on the basis of the inquiry report, and by observing the principles of natural justice. And if such steps are being taken, the petitioner would be at liberty to take such defense as permissible under law. In such circumstance, the observations so made herein above as regards the inquiry report shall not affect or prejudice any of the parties.
Much obliged.
Yes, you have not filed the affidavit?
Not yet.
Why? You are not interested. Why should we allow any contempt in this case when you have not done it?
The senior person,
Senior? What senior? The senior, earlier the matter has come up. I gave the permission to file an affidavit showing as to whether the order passed by this court have been duly communicated. Why don't you do one thing, communicate it and then come before this court? Unnecessary keeping these matters pending. Huh? Do that. You have still time.
3 weeks may be given, we'll proceed with the affidavit.
Huh?
Kindly, 3 weeks may be given, we'll proceed with the affidavit, your lordship, as soon as our senior is.
I gave you 1 month. Go and communicate. Better, why don't you go and communicate and then come and file it? Leho. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The instant writ petition has been filed alleging willful and deliberate violation to the order dated 18/8/2025, whereby the learned coordinate bench of this court disposed of the said writ petition with a direction to comply with the directions passed at paragraph number 16 in WPC number 6582/2023. This court, while taking up the instant contempt application on 5/1/2026, inquired with the learned counsel appearing on behalf of the petitioner as to whether the order dated 18/8/2025 passed in WPC number 1132/2024 have been communicated to the respondents who have been to the respondents who have been arraigned in the instant proceedings. And in that regard, also granted the leave to the petitioners to file an additional affidavit. Petitioners. However, no additional affidavit has been filed in that regard. Under such circumstances, it is therefore the opinion of this court that since intimating the concerned respondents about the order dated 18/8/2025 passed in WPC number 1132/2024, the question of willful or deliberate violation to the orders passed by this court does not arise. Under such circumstances, this court is not inclined to issue notice in the instant application, for which the instant application stands closed. Liberty, however, is given to the petitioner to intimate the respondents herein, and thereupon approach this court, if so permissible, otherwise in law.
Much obliged, your lord.
Where are you, Mr. Ardhor? Where is he? I saw him somewhere. You are there on this matter. Stands deferred to be listed after 3 weeks. Request made by Mr. Ardhor. Where is it? What is the case here?
Yes, my lord. Petitioner successfully passed medical test and PhD miller. And after treatment from my I appeared me. In the written test, they have successfully come out. And
So what is your grievance?
grievance, my lord,
They have not intimated
they have
to you
yes,
what has happened.
what happened in the Viva.
And what has happened? You have been issued notice, you are asked to obtain instructions.
Lordship, the department sought from some time, Lordship.
Does it take time? How long you have been taking time? 1911. From 1911, the department wants time. I'm not going to look into this type of things.
Next week, Lordship, I will.
Not next week, 2 o'clock.
Lordship,
2 o'clock, we want the instructions. Otherwise, we have this particular person at 4 o'clock.
Lordship.
Don't come up with this, Mr. Goswami. What is this? It is shameful on the part of the department to seek an instruction that you want to provide instruction 2 months, 3 months, 1911. Isn't this shameful on the part of the department? When the notice was issued on 1911, we'll have it at 2 o'clock.
I will do.
Get the instructions.
No, notice go same. Apne orders.
May I please your lordship?
Yes.
The engaged counsel, Mr. N. Kumar, he made an excellent, your lordship.
Who?
Mr. Naveen Kumar. Mr. Naveen Kumar, the engaged counsel, your lordship, will make. an
You are
excellent-
there. Yes, madam.
Lordship will file an affidavit, Lordship, Paraguay's comment received.
What is your parawise comments? His case is specific. Then look here. It is only the courts who can grant interim maintenance. Who are you?
Lordship, I'm the Air Force. Application has been filed to the authorities.
Do you have the power?
Lordship, yes.
You have the power.
Section 91 of the Air Force Act, Lordship.
Let us see that. 91 of the Air Force Act. Where is the provision of 91?
Lordship, I'm not the engaged counsel, your lordship. The engaged counsel made an excellent. your lordship.
It may
The
be
matter
taken
of
up on
the-
Friday, Lordship. I will file a affidavit in the meantime, Lordship.
I don't need an affidavit in opposition. My only question is, there is a judgment also.
Yes.
Air Force Act 91. The following penal deductions may be made. Yes, under which provision? So this is being done under 91I.
Yes.
Chalo. Any sum required by order of the central government to be paid for maintenance of his wife or his legitimate or illegitimate child, or towards the cost of any relief given by the state government to the said wife or child. Then 92. Chalo. We do one thing, we issue a notice to you
Yes, sir.
and you file your affidavit after 4 weeks. In the meantime, maintenance is going on, you are making the payment.
No, process is going on, Lordship. Process is going on. Maintenance not paid till then.
Okay, we pay, no problem.
At pace, you 50, Lordship.
Should I give an approval
Lordship,
that you should pay,
yes.
maintain? Issue notice making it returnable on 9th of March 2026. Ms. R. Devi accepts notice on behalf of the respondent numbers 1, 2, 1, 2, and 3. As regards the extra copies of the writ petition be furnished to her during the course of the day, by tomorrow. As regards the respondent number 4, steps be taken by way of speed post by tomorrow. Why you're making the respondent number 4 a party?
Is the wife, Lordship.
A wife? 4 by way of, yeah. by speed post. In addition to that, liberty given to the petitioner to serve the respondent number 4 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner is a serving officer of the Indian Air Force. Full stop. An application was filed by the respondent number 4 seeking maintenance allowance from the Indian Air Force. Full stop. The respondent authorities duly intimated the petitioner about the said. Full stop. The petitioner apprehending that interim maintenance order would be passed in favor of the respondent number 4 has approached this court. This court have issued notice, this court have sought for instruction by an order dated 10/12/2025. Ms. R. Devi submits that she has obtained the instructions. It is the case of Ms. R. Devi further submitted that in terms with Section 91 I and Section 92 I of the Air Force Act 1950, such deductions or penalties can be imposed. Full stop. It is therefore the opinion of this court that the said aspect be brought on record by filing an affidavit. Full stop. The pendency of the instant writ petition, however, shall not bar the respondents to take such actions as deem fit as regards the application filed by the respondent number 4.
Lordship, may kindly pass the matter for time being by senior Mr. A.A.R. Karim is in another court.
Who?
A.A.R. Karim, senior.
Where is he?
My lord, he is in court number 25.
This weight is being looked into by the review medical board.
Overweight, whether he is overweight, normal weight is the obesity,
Basically,
that is,
then he sought for a review also.
yes, Lordship.
And review it was found
Both rejected him as overweight.
12.25 kilos.
Yes,
Overweight. Weight is 64.
yes.
And then
He go to the.
instead of weighing machine is there, he goes out there to the medical board. Some college where,
Raja Medical College.
and they gave it 56.
Yes, Lordship.
Exactly on that. Hello, we adjourn it for the time being so that we can dismiss at the hands of his senior. No? This is not a case for issuance of notice. We should dismiss it. So let your senior come.
Obviously.
Yes, Mr. Dhar.
My lord, my senior, my lord.
Why there is no minimum wages paid?
My lord, I'm not sure actually, this, if I go by page 16, these are few documents that is only their credential they are trying to harp upon, my lord. These are, my lord, just typed some experience certificate, nothing more.
But are they working?
Yes, my lord, this also.
Yes, yes.
Where is the certificate that you are working?
Certificate.
My lord, at least some pay slip, they are getting some remuneration, whatever, my lord. At least that.
File additional affidavit. These materials does not show that you are working or you are receiving some salary.
Because government gives nothing in cash. Anything, my lord, it has to be through either in bank account or check, something like that, my lord.
No. The materials on record do not show that the petitioner are presently engaged in the handloom and weaving establishment, handloom and textile department of the government of Assam. Mr. A. Dasgupta, the learned senior counsel, submits that he would instruct his assisting counsel to obtain instructions from the petitioner and, if necessary, file an affidavit, additional affidavit. List this matter. How much time? 1 month, 1 week, 2 weeks?
Subject to your lordship convenience.
My convenience is not the convenience is yours. You have a case, you have a case, but at first that Mr. Rajgupta, you need two things. One is bringing on that, and second way is the notification under Section 5. Why haven't you brought the notification under Section 5?
No, no, so far minimum wages is concerned, that is being paid to us.
Then
We are here before your lordship to have our scale paid. We have been working since 1994 onwards. That is not the case that minimum wages is not paid. We are getting our minimum wages. And these court has got an occasion to pass such an order long back. And minimum wages is being made throughout Assam in all centers.
then
Jolhat and Guwahati, Sibsagar, Nalbari. So we approached before this court on 2 occasions to have our scale paid. And this court has also passed an order in favor of some of the workers, some of the persons. That is the Annex D. But this order is not being implemented. And subsequently, the Nalbari people has come before your lordship to have the minimum scale of pay. It is not the case that we are not getting our minimum wage. We are getting our minimum wage still. Look.
oh,
Page 24, the order was by Honorable Justice D. Biswas. Since long back, Lord. It was passed in the year 2007. Then the employees who are working at Jorhat, they approved before this honorable book to have the scale pay. And this honorable board also passed such an order. Despite that, nothing has been done. Now the nobody people has come before your lordship. I don't know what will be their fate, but they are getting minimum wages. Till date.
So you are getting minimum wages.
Yes.
Now you want the minimum scale of pay,
That is it.
which is as per Upendas.
Yes. And nothing.
Because you have rendered 10 years of service.
Yes. All of them. As per report.
But how do we know, Mr. Dasgupta, that you have rendered 10 years of service?
That is of course a problem. Let them come with a affidavit.
My lord, it is their case. They have to show.
No, why will you come? They will have to come
Yes,
for
ma'am.
issuance of notice. Either you should have moved 1 month before and got a similar order, but I'm not going to pass an order like the coordinate bench.
All that, no order. required.
Unless and until you show that you have been working
More than 10 years. Or more than 20 years.
more than 10 years. You see, Upenda's case, as per the state and as well as the finance department's thing, is that you have to work 10 years prior to 1/8/2017.
The recent Supreme Court judgment is also there. Jaggo case.
Jaggo is altogether different.
Yes.
Which one?
Jaggo, my lord. Jaggo.
And Jago no, would not apply here. We are not asking for Jago. Jago is regularization. Correct.
Scale vendor at this stage.
Asking for scale of pay.
Monthly scale of.
My lord, scale
But
of pay is
applying
basic-
as per Jagjeet Singh, huh?
scale of pay was basically for my lord, master roll worker and WhatsApp employees, my lord. Here, their contractual, their, my lord, the thing is that we have to first see what is their employment basis. They are given some yarn, my lord, and in that way they design clothes. So we'll have to first look into whether they are a regular worker, regular, I mean, my lord, master roll or work church.
No, regular and continuous.
Continuous, yes, continuous, my lord. Whether they are into it, my lord.
There has to be
That
continuity.
aspect-
There has to be
continuous.
continuity. It cannot be just you come today, after 2 months you are again engaged and you come thereafter. So there has to be minimum continuity.
Yes, my lord. Let them come up, my lord, with something, my lord.
The bank account, Lord.
For
Some time ago.
the materials on record do not show that the petitioners herein are engaged by the handloom and
Handloom and textile.
textile department of the government of Assam. So under such circumstances, in that view of the matter, when pointed out, Mr. A. Dasgupta, the learned senior counsel, submitted that he will instruct his assisting counsel to obtain instruction and if necessary, file an affidavit in that regard. Pustak, list, ma'am.
Yes, ma'am. Sorry, please.
What is that?
But approved before this honorable court in the year
Now, are you working today?
2012 itself.
Forget about that. Therefore, my word is as on today. Are you working? How can you get it? In 2012, you were there. It is not there.
All right.
This is the matter on 2026.
All right, I will pay.
7.
Yes.
This that distinction from service. Appeal is pending. Because with the subsistence allowance is also not being paid law.
Lordship, in regards to the appeal, Lordship, and regarding the substituent allowances, Lordship, I received the instruction, Lordship. এটু লব দাদা এটু লব এটু appeal to 9 minutes. Disable this.
Where's the receipt of this document, Annexure 6? Huh? Oh. You send it by post
Yes.
on
2811.
huh?
2811.
And then immediately approach this court. Huh?
Yes.
Where's the receipt? Track confirmation that this was received.
Message was given to him, Lord.
You said that this document, Mr. Sharma, kindly don't put yourself in bigger trouble than this. This is a document on 28/11/2025. Have you seen this? You filed a writ petition enclosing Annexure 6 and said that you submitted the document. And you filed a writ petition on 25/9/2025. How on earth this is possible? Are you aware when you filed the writ petition? 25/9/2025. You have enclosed that you have filed an appeal. And then you place before me this particular postal sheet wherein it says that on 28/11/2025, isn't it? 28/11/2025 you said it. Means this is a case of falsehood and you are also trying to mislead this court, Mr. Sharma. I think this is a case of strong action to be taken against you. Why I should not report you to the Bar Council? Tell me. Why I should not report you to the Bar Council?
Was under defect, Lord. This case was under defect, Lord.
But you enclosed that document as Annexure 6 to the writ petition. And filed the writ petition on 25/9. If that is so, it is a false statement made by you that you have filed this application and have therefore approached this court.
Maybe he didn't file the earlier, Lord, but this was also taken up before the authorities on that date. On that date.
When?
On 25. 25.
When did you submit this document?
28/11. Lordship, he again gave it to the authorities filed this.
Chalo. We asked this, you have a CBI, what do you call the CID? To make an investigation against Mr. MP Sharma.
What's it?
And record this video also about this thing. And then put it before the Bar Council. We'll take you to task for making a false statement before this court.
Withdraw.
Lordship, I withdraw my statement.
You cannot withdraw now. And till then, there should be a suspension of your license. Why we should not suspend your license? We keep this matter pending only for the purpose of that, asking you to show cause why your license should not be, why proceedings for criminal contempt should not be initiated for making false, misleading statements before this court. This very submission was made on the last occasion also by Mr. Ardhor, by Miss U Sharma. Yes, I remember. She also made that this particular document, I said, okay, Mr. Goswami was not there, we'll look it today. Then also you had the audacity to place this document.
Grant me some time, I will verify it.
No, you cannot now. You are making this statement out here. That is why I saw it. And if I didn't look into the date of filing, I would have told you, yes, you have filed and come back. Lehok. Heard Mr. MP Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. J.K. Goswami appears
On behalf of
on behalf
all
of
all the respondent lordship here.
all the respondents. Did you file the wakalatnama, Mr. Sharma?
Yes, Lord.
Wakalatnama kaun sa? Asan na yung lamp na? We can't trust you. Everything you say has to be taken with a pinch of salt. The present petition has been filed by the petitioner. Challenging. No, you cannot. The order of suspension dated 5/11/1999. The show cause notice dated 6/1/2000. The note sheet dated 26/5/2004. As well as the order dated 25/4/2005, whereby the petitioner was dismissed from service. Full stop. The case of the petitioner herein is that an FIR was lodged against the petitioner alleging that the petitioner have committed robbery on 4/11/1999 along with others at one Prabhu Dayal Beriwal's house. The said FIR was registered as Dibrugarh PS case number 389/1999. On the basis of the said FIR, the petitioner was arrested. Subsequently, the petitioner was released on bail. And it is alleged by the petitioner that the petitioner came to learn from reliable sources that there was an order of shoot at sight. Be that as it may, on the basis of the petitioner's petitioner's arrest on 4/11/99, the petitioner was put under suspension by an order dated 5/11/1999. Thereupon, a departmental proceedings was initiated. The petitioner admittedly received the show cause notice, but he did not reply, alleging that he feared thereupon the departmental proceedings proceeded. And the petitioner was terminated. Was dismissed from service for his unauthorized absence. By an order dated 26/5 by an order dated 25/4/2005. Full stop. In the meantime, the criminal proceedings which was initiated against the petitioner charge sheet was filed and by an order dated 27/5/2019, the petitioner was acquitted. Full stop. It is the case of the petitioner that the petitioner thereupon submitted a representation to the Deputy Inspector General of Police, thereby to set aside the order of the penalty of dismissal from service dated 25/4/2005. It is the case of the petitioner that the said representation was not looked into, and as such, the petitioner has therefore approached this court. This court have perused the said representation, which is at Annexure 6 to the petition. Surprising, the representation does not contain any date. Full stop. Be that it may, the writ petition was filed on 25/9/2025. Full stop. This court, when the notice was issued by this court on 15/12/2025, when this court, no, on 18/12/2025, the counsel who represented the respondents sought for time to obtain instruction as regards the appeal filed by the petitioner. Today, when the matter has been taken up, an instruction has been placed before this court by the Assistant Inspector General of Police, dated 21/2026. The said instruction is kept on record and marked with the letter X. The contents of the said instruction, and in terms with the said instruction, it is stated, it is mentioned that the document which has been enclosed as Annexure 6 to the writ petition has been placed before this court for the sake of initiating the litigation only. It is also mentioned that the petitioner has misled this court and committed perjury by filing the petition with falsified documents. It is also in addition to that, it is also mentioned that no appeal was ever filed by the petitioner, and the issue of disposal therefore does not arise. This court, in view of the said instructions, inquired with Mr. M.P. Sharma, the learned counsel who represents the petitioner, as to what is the date of enclosure of Annexure 6. He submitted that Annexure 6 was sent by post on 28/11/2025. And in that regard, the postal receipt was handed over before this court during the course of the hearing. এখন পেস্ট করি বোকা কাগজ এখনত মার্ক করি। The said postal receipt is kept on record and marked with the letter Y. Pusto. This court now fails. This court fails is perplexed and flabbergasted by the fact that, on one hand, the petitioner have enclosed the representation as Annexure 6 to the writ petition and filed the writ petition on 5/9/2025. And on the other hand, the counsel, appearing on behalf of the petitioner, places before this court a postal receipt dated 25/8/11/2025. First, it therefore appears that what is alleged by the respondents in the document kept on record at marked with the letter X appears to be true. The above aspect makes one thing very clear, that an attempt was made to mislead this court. On this ground itself, the writ petition is required to be dismissed. And by imposing exemplary costs. Be it as it may, this court further finds it pertinent to take note of that the department proceedings was adjudicated, was carried out solely on the basis of the allegations and uninfluenced by the criminal proceedings. Inasmuch as the criminal proceedings came to an end only by the judgment and order dated 27/5/2019. Whereas the petitioner herein was dismissed for service by an order dated 25/4/2005, almost 14 years prior. It is no longer res intriga that the manner of proof in respect to a departmental proceedings as well as a criminal proceedings are different, in as much as in a criminal proceedings it is the prosecution who has to prove beyond reasonable doubt, whereas in the case of a departmental proceeding it is preponderance of probabilities. In addition to that, it is an admitted fact that the petitioner was in unauthorized leave. Under such circumstances, this court does not find any ground to interfere with the impugned departmental proceedings as well as the orders passed, thereby dismissing the petitioner. Another very relevant aspect of the matter is that the petitioner have another relevant aspect of the matter which also requires consideration is the additional affidavit filed by the petitioner. Wherein the petitioner averred the reason why the petitioner could not take steps. The materials on record show that these prescriptions are of the year 2001 2000 and 2001. And the last date mentioned is of 2003. The petitioner was dismissed from service on 25/4/2005. And the petitioner and the materials on record do not show the petitioner had no knowledge about the same. On this ground also, this court does not find the present case to be a fit case for even issuance of notice. Accordingly, the incident with petition stands disposed of, stands dismissed, disposed of with the following observations and directions. Number one, the writ petition stands dismissed. Number two, This court deprecates and reprimands both the petitioner as well as the counsel representing the petitioner for their conduct to mislead this court. This court hopes and expects that the counsel representing the petitioner shall mend his ways for the future.
With regard to that substances allowance, if it has not been paid, lordship, he may approach this court.
What?
With regard to that subsistence allowance.
Nothing. Misleading the court, this court is not going to go even. Yes, what case you have? You are not in service from 2005. Merely because the letter has been written, how does it make any sense? Huh? Your name being not sent, how does it matter?
My lord, as I have been working more than 10 years, my lord, so my name is to be changed, that is my prayer.
No, you are not there for the last 20 years. You last worked in the year 2005. Thereafter, for 20 years, there is no name, nothing. Then in 2024, somebody's name was sent who worked for the last 10 years. And now you say, come here in the year 2026, that look here, my name also should be sent.
My lord, who has working more than 10 years, and in fact, the DDS scheme was established 2007, my lord. Scheme was established, nobody in the scheme after 2007. And the SPA operation, so only I have an instruction by the respondent authority going to send my name.
Your name was sent when you were 34. You worked last when you were 34. Now you are 54.
How they have thought, my lord, only now they have checking, my lord.
Yes, why this letter was issued?
Lordship, that instruction, Lordship, I have, Lordship, some list were forwarded to the joint director thereafter, Lordship, and it has already been sent so far as my telephonic instruction.
Huh?
That 24 list, Lordship, that 24 later, Lordship, which sought for some names, Lordship, who worked for more than 10 years, Lordship.
Yeah.
Those names were already forwarded by the joint directors of the districts.
Hmm.
And the list has been forwarded, Lordship, so far as my telephonic instruction, Lordship.
Then?
And those names were only for those people who worked, Lordship, 10 years prior to 2017, Lordship.
Hmm. Now the petitioner is not working.
No, not,
Huh?
nothing, Lordship.
I have heard Mr. M. Hussain, the learned counsel, appearing on behalf of the petitioner, Mr. D. Upamanyu, the learned standing counsel, health and family, and Mr. D. Upamanyu, the learned standing counsel of the Health and Family Welfare Department. The grievance of the petitioner or petitioners, how many of the petitioner herein is that the petitioner name was not forwarded by the Joint Director of Health Service when a letter was issued, communication was issued by the Joint Director of Health Service cum SPO, NVBDCP dated 9/4/2024. And as such, the petitioner has approached this court. The materials on record clearly show, and more particularly, the representation submitted by the petitioner, the undated representation submitted by the petitioner dated enclosed as Annexure 7 clearly show that the petitioner claimed that he had worked from 1986 to 2005.
2020. Next line.
Where? Where's the date?
And the 7, my lord.
Huh?
After prayer, my lord, date has been.
After prayer?
Forwarding the name of seasonal DT spray worker.
Where?
My lord, page 21, my lord.
Huh?
After prayer, after subject, date has been.
Or date 35 or 35 2024. In the representation data, undated novel dated 35 to enclosed as Annexure A. That the petitioner worked for 20 years from 1986 to 2005 in the DDT spraying work under malaria department. And therefore his names also should have been sent. Proceed. Mr. Upavinder, why have you asked for this letter?
Lordship, so far as my telephonic instruction, they wanted to have a list of candidates who worked prior to 1/8/2017 for more than 10 years, Lordship.
So you are doing it in terms of Upendas.
Yes, probably more, Lordship, because that date itself, Lordship,
So are you still giving the minimum scale of pay?
Lordship, that instruction I do not have, Lordship, because these are all seasonal workers, Lordship. So, Lordship.
If they are seasonal workers, then how can you give?
Yes, Lordship, Upendra.
It can't be Upendas.
Yes, Lordship. But that is my telephonic instruction, Lordship. Otherwise, DTT spray, Lordship, they are otherwise seasonal workers, Lordship.
Nestle Vector. And Mr. Counsel, why? If it was sent, what you would have been? Has any other person other than you been given any benefit?
Till date, as per information, till date not given, but as per information from my client, my lord, the restaurant is going to engage them to some scheme, my lord. And till date, they are forwarding their names. And in fact, my lord.
Some scheme.
No, that is I am not aware, my lord.
The last 20 years, you must be doing some other work.
Yes, my lord.
So,
I am also, my lord, without claiming anything, I am
Okay.
also waiting, but
last line to ki likh le?
issued this letter, therefore I am.
Then, Gusto. This court therefore inquired with the learned counsel appearing on behalf of the petitioner as to what benefit the petitioner would get if his name is forwarded in terms of the communication dated 9/4/2024. And as such, by an order dated 21/1/2026 granted time to the petitioner to obtain instructions. The learned counsel appearing on behalf of the petitioner submits that those names, that as per the instructions of the petitioner, that those names which should be sent, they would be engaged in some other work. Full stop. However, and the learned counsel further submitted that, however, no benefit till date have been granted to those persons whose names have been sent. Considering the above, this court therefore is not inclined to entertain the instant writ petition at this stage, taking into account that there is no deprivation of the petitioner of any right. Full stop. And further, nothing could also be shown. Accordingly, the instant writ petition therefore stands dismissed. Liberty, however, is given to the petitioner in the circumstance when similarly situated persons like the petitioners have been granted benefit on the basis of the communication dated 9/4/2024.
Here I'm praying for the entire. Also, the petitioner, the husband of the petitioner died on 1/1/2003, Lord. And
Bad case.
she received the compensation in November 2023. The last occasion, Lordship, with regard to that, whether there is a provision in the amendment and that will entitle me with regard to the interest. And I am relying upon two cases, Lordship. Hearing, Lordship, Union of East India versus Parmat Singh. This case, Lordship. There was no statutory provision under the Defense of India Act, Lordship, for providing interest. But Lordship will kindly peruse paragraph 1 and 2, will kindly peruse them. 8, 9, 10, or 11.
Which judgment you are referring to?
Lordship, that Union of India versus Parmal Singh. In that case, paragraph 1, 2, then 8, 9, 8, 9, 10. 10 and 12, Lordship.
Kindly come to paragraph 11 and read it.
In this case, the acquisition is of the year 1965. Though more than 4 decades have elapsed, the landowners are yet to get the compensation in entirety. It is also relevant to note that when the arbitrator awarded interest, it was not challenged by the applicant. It accepted the award of interest even when the High Court increased the amount of compensation. The appeals filed by the landowners. The appellant chose to challenge not to increase in compensation but the award of interest. Either does it pay, then. So, Lordship, hearing that was put to challenge, and the other judgment, Lordship, Jagdish Rai, hearing in this case, Lordship, paragraph 1, Lordship will continue. Hearing, Lordship, before the sub-judge, Lordship, there was no prayer with regard to payment of interest. But subsequently, the prayer was made before the High Court. And
second page, the paragraph before the last, second last paragraph.
This paragraph.
Yes, Doctor. Herein also, in the present case, the applicant has
The claim for interest.
the claim for interest not having been made before the court in which proceedings for making the award, the rule of the court were pending. It certainly is entitled the applicant for making such a claim during the first three stages of the arbitration and post arbitration. That is between the award and filing of the application. But the several considerations will have to be examined before award of interest and at what rate. Therefore, when the award had not been challenged for not granting interest, the award could not be upheld to that extent. The view taken by the High Court appears to be correct to that extent. However, that is not the end of the matter. The High Court ought to have further examined whether the applicant was entitled to any interest after the decree was made in terms of the award. The courts have taken the view that award of interest under section 34 of the CPC is a matter of procedure and ought to be granted in all cases where there is a decree for money unless there are strong reasons to decline the same. In the present case, the applicant had made a claim for interest before the arbitrator, but the same had been denied and no reasons for forthcoming thereto. Whatever that may be, at any rate, after the subject made an award, the rule of the court, the decree ought to contain a provision for making payment of interest. If such payment had not been made, appropriate correction of the decree could be ordered to be made when an application has been made before the High Court.
Bad case. Not a case for issuance of notice.
Otherwise, similarly situated persons were identified.
See, the question is, when you file the writ petition in the year, whatever may be, earlier, you should have come clearly with the particular statement that you wanted interest. The court could have granted the interest at that point of time. You did not ask for that. Now you want, after the court passed that order, which has attained finality, now you want that this court should sit over that order and direct him that, okay, now you pay from 2003.
The other judgment, that is Union of India versus Parmal Singh. Therein, Lordship, an observation has been made with regard to the equity, Lordship. With regard to the court must see with regard to the.
There's no equity business out here. Why did you wait?
Because he died in 2003, Lordship, and there wasn't.
Understood. You should have been granted an interest then. But you have approached this court later on, now for interest.
Anything with regard to approaching the court, Lordship. Whereas
Where is it said that you are entitled to interest? Show me in the office memorandum. Then
this judgment, Lordship, Union of India versus Parmal Singh, Lordship. There is no statutory provision in the Defense of India Act, Lordship. And similar is the case with regard to railways also, Lordship. Under the railways, whenever compensation is paid for death, Lordship, or any other amputation or something like that, Lordship, there is no provision under the statute for any interest, payment of interest. But then that is being paid, Lordship.
So now you want that I should review that order.
Why that is being paid, Lordship? There,
No case. Division bench may help you. Heard Mr. MP Sharma, the learned counsel appearing on behalf of the petitioner. Mr. UK Goswami appears on behalf of the respondents. The petitioner herein has approached this court seeking a direction upon the respondents to pay interest at the rate of 9% on the ex gratia payment of rupees 5 lakhs with effect from 1/4/2003. That is 3 months after the death of the petitioner's husband till 1/11/2023, when the petitioner received the ex gratia payment. Full stop. The facts, as would show from the materials on record, is that the petitioner's husband
The question, Lordship, has been answered in Jagdish Rai, Lordship, this question, Lordship, with regard that subsequent asking of interest as well. Your Lordship, kindly produce a spare.
one Raman Kumar, since deceased, joined the General Reserve Engineer Force in May 1988 as operator of excavator machine. Full stop. Unfortunately, the petitioner's husband expired due to an accident on 1/1/2003. Full stop. In terms with an office memorandum bearing number 45/55/97-P and PW(C) dated 11/9/1998, an ex gratia lump sum compensation is paid to the families of the central government civil services who die in harness. This aspect is apparent from paragraph 5A of the office memorandum dated 11/9/1998, which stipulates that on account of death occurring due to accidents in course of performance of duties, an ex gratia payment of rupees 5 lakhs would be paid. The materials on record show the petitioner claimed the said amount but the same was rejected by an order dated 29/1/2016 on the ground that at the time of the accident, the death of the petitioner's husband, he was not on government bona fide duty. Under such circumstances, the petitioner approached this court by filing a writ petition, which was registered and numbered as WPC number 5742/2019. The reliefs which have been sought for in the writ petition being relevant is reproduced herein under page 29 of this. In the premises, page 29 of this. 30. The said writ petition was disposed of by the learned coordinate bench of this court by an order dated 10/4/2023. . holding inter alia that the benefit of the OM dated 11/9/1998 for payment of ex gratia cannot be denied to the petitioner who is admittedly the widow of a central government civil employee. Accordingly, this court directed release of the said amount to the petitioner in terms with the OM expeditiously and preferably within an outer limit of 2 months from the date of the said order dated 10/4/2023. The petitioner thereupon received the said amount on 1/11/2023. Full stop. The petitioner, upon receipt of the said amount, kept quiet, and thereupon, after a period of almost 2 years, and after a period of 2 years, filed the instant writ petition on 15/12/2025, now claiming interest with effect from one 4/2003 at the rate of 9% till the date of payment, that is 1/11/2023. Full stop. The matter was listed before this court on 5/1/2026, wherein the counsel appearing on behalf of the petitioner sought for time to address this court on the ground as to whether the petitioner can re-hesitate the said claim after having not sought for any interest at the time of filing the earlier proceedings, and that too without even approaching the respondents seeking interest. Today, Mr. MP Sharma, appearing on behalf of the petitioner, drew the attention of this court to the order dated 16/9/2019, passed by the learned High Court of Punjab and Haryana in CWP 8183-2018, and submitted that the learned Punjab and Haryana High Court have awarded interest at the rate of 9%. In addition to that, the learned counsel have also placed before this court the judgment of the Supreme Court in the case of Union of India versus Parmal Singh and others, reported in 2009 1 SCC 618, as well as the judgment in the case of MS Jagdish Rai and Brothers versus Union of India, reported in 1999 3 SCC 257. Full stop. it is very pertinent to take note of. That in the earlier round of litigation, that is in WPC number 5742/2019, the petitioner never claimed any interest. And the relief which was sought for, as already quoted herein above, was that the petitioner only, that a direction be issued to pay the ex gratia lump sum compensation to the petitioner. The learned court bench of this court by the order dated 10/4/2023 also did not pass any direction for payment of interest. And specifically directed payment of release of the amount within a period of 2 months from the date of the said order. This court have also taken note of the orders passed by the Punjab and Haryana High Court, wherein it is apparent from a reading of the said order itself that the interest was claimed along with the ex gratia, and the ex gratia was paid only during the pendency of the said writ petition. This court have also taken note of the judgments placed by the learned counsel appearing on behalf of the petitioner in the case of Parmal Singh Supra. And the facts involved therein under no would not apply to the facts of the instant case. At this stage, this court finds it very pertinent to observe that there is a fundamental difference between the fact when a court passes an order for payment of the principal along with an interest irrespective of the fact that the statute does not conceive of payment of interest, from the fact that when the court only passes an order for payment of the principal without exercising its jurisdiction to make payment, to direct payment of interest. In this case, it is apparent. In the present case, it is the later, inasmuch as by the order dated 10/4/2023, there was no direction to make payment of interest. Therefore, the judgment in the case of Parmal Singh Supra would not apply. Similarly, in the case of Jagdish Rai brothers Supra also, the facts are different. Wherein, inasmuch as the issue involved therein pertains to whether the arbitrator has the jurisdiction to direct payment of interest post the award, even though there is no claim for interest for interest prior to the award, prior to filing of the arbitration proceedings, or pendant light. Full stop. This judgment also does not help the case of the petitioner. Next. In the present case, it is also very pertinent to take note of that the petitioner duly received the amount on 21/11/2023 and even did not submit a representation and have directly approached this court on 21/1/11/2023 and did not approach the respondents and directly approached this court. What the petitioner now seeks is in the form of a review to the order passed by this court on 10/4/2023 in so and so by initiating the present litigation. First, it is the opinion of this court that such that opinion of this court that entertaining such dispute by issuance of notice would be nothing but an abuse of the process of the court. Accordingly, this court does not find any merit in the instant writ petition to issue notice for which the writ petition stands dismissed. Yes. Your weight.
Overweight, yes.
Overweight.
But on subsequent.
What did you have? To reduce your weight within 4 days so much?
Physiology.
You were 61 in the detailed medical examination.
Blood
61.
61.
Then you became 64 in the review.
Review.
And then immediately you became 56.
And
How is it possible?
Kokrasar Medical College and Hospital. Yeah.
Kokrasar Medical College is the main. Na?
That's the only prayer is transgeology or allow me to find a recommendation.
No. That cannot be
Similar
given.
or
Weight
different,
is
right?
nothing to do with that. Representation, the weight it will be opening a Pandora's box in this case. Some other thing is different. But what is there? This is not a medical opinion. I can also decide. When these people have found you that your weight is 64, overweight, then what remains? Okay. You don't need a medical opinion for that. Do you require?
No.
Madam? You
No.
also, I also can do it by seeing the weighing scale. Unless you allege that the weighing scale is wrong. But there are two authorities who found out. Why should we entertain this type of petition? Therefore, I did not issue notice. If that order would have been passed, I would have passed in his presence only. I wanted that Mr. How many A? 2 A's. Double A. The A.R. Karim comes in to dismiss the petition. No? Yes. Wait. In the meantime, you have already published a provisional list. No?
Yes, Lordship.
No? Why should we open up all these things? And you filed it when? 2/12. Huh? 2/2. When did you file it? 2/12. And then? Why the matter is not, nothing is there? Must be some defect. Oh, notice.
With two times.
Yes, Miss Borua, did you? Praise
Notice
not
not
of,
issued.
huh?
Notice not issued.
Not issued.
Yes.
Any instruction from your side?
No, Lordship, instruction not
And
received.
you have been asking for time.
Yes, petitioner took time.
Whenever the matter has come up, matter came up on 12/12, you took time. 16/12, you have taken time. No? When everything is opened, you want to unscramble an egg. Something like that. Dismiss. Can't help you. Your wait is over. Because these overweight things, if this court starts interfering, yes, there might be certain things pertaining to some examination which this court is not aware. But here you can't. You were found everywhere. In 2 eyes, you have been found this. And Kokrajhar, na? Kokrajhar finds out 56.
Medical college. Okay.
Medical college is right. The scales are right in medical college. Are you alleging the scales which have been used out there in those two places are wrong?
What is changing? That time to time, your lordship, what is changing?
Why have you taken time? If it was the first day, I would have thought it. You have taken so much time. No. Leho, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S. Burwa appears on behalf of all other respondents. The petitioner herein is aggrieved by the rejection of its candidature in the recruitment process initiated by the notice dated 5/9/2024 on the ground that the petitioner has been declared unfit as he is overweight. It is pertinent to take note of that in the detailed examination, medical examination which was carried out, on 20/11/2025, the petitioner's weight was found at 61 kilos. And in respect to a category where the range was from 42.5 to 51.75 kilos. Thereupon, the petitioner sought for a review. And in the review examination also, the petitioner's weight was found overweight. Petitioner was found overweight. In as much as his weight was measured at 64 kilos, height how much? What is the height? You don't even have the year, huh?
59.4.
159.
Yes, 159.
Height should be 165. How is it height? Oh, lady. Lady will be less,
Yes.
na? Height 159.4 cm and BMI 25.18. It was opined that the petitioner was overweight by 12.25 kilos. It is a case of the petitioner that thereupon on 26/11/2025, the petitioner got herself measured, her weight measured at Kokrajhar Medical College Hospital. And it was found that her weight to be 56 kilos. The petitioner thereupon submitted a representation on 27/11/2025. Where is the receipt? No receipt.
Copy is supplied.
on 27/11/2025. And the same having not been considered, the writ petition was filed on 2/12/2025. It is noticed that when the matter was listed before this court on 12/12/2025, the matter was adjourned to 16/12/2025. On 16/12/2025, when the matter was listed, the petitioner sought for an accommodation for 3 weeks, and therefore the matter has been listed before this court today. Full stop. It is not a rocket science. As regards the measurement of a person's weight, both the detailed medical examination as well as the review medical examination categorically held that the petitioner was overweight. Full stop. Under such circumstances, this court does not find, on the basis of a certificate issued by the Kokrajhar Medical College, to entertain the instant writ petition. Certificate of the Kokrajhar Medical College that the petitioner is 56 kilos, to entertain the instant writ petition. Full stop. This court also have perused the contents of the writ petition. Wherein also there is no allegation that the weighing device used both in the detailed medical examination as well as the review medical examination is or has any faults. Under such circumstances, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Yes, Mr. Chakraborty.
Contempt petition order starts from page 14. The relevant part, your lordship will find at page 16, paragraph 6. May I read that? In view of the aforesaid admission of entitlement of area salary and other post-retirement dues, this court is of the opinion that this petition can be disposed of directing the director in the Animal Husbandry and Veterinary Department to carry out necessary actions and file a fresh proposal for the payment of admitted arrears of salary and other retirement dues due to the legal heirs of the deceased government servant, namely so and so, within a period of 4 weeks from today, and thereafter duly assist the finance department for doing the needful. A copy of the order shall also be furnished before the Commissioner and Secretary, Finance Department, Government of Assam, for his notice, so that once such proposal is submitted and necessary approval is sought by the Finance Department, the Finance Department can.
Animal husbandry, who appear?
Ms. M. Kotoki appeared in this case.
Where is she?
Yeah.
Animal husbandry. And finance?
Finance, on the last occasion, Mr. P. Gogoi, in fact, was intimated about. But my lord, here one thing, and the rate petition finance was. Was not.
Mr. Nayak is also here.
Oh, yes.
Good. Mr. Nayak, this is a contempt file.
Not yet.
I normally don't issue notice first because it is a trouble for these officers. Just find out why this is not being complied with. Then we'll look into it. I'll give you time for 3 weeks. Have a look at it. What is wrong with it? Huh?
My lord, one thing may I point out?
Yes.
This petition, though finance was not a party, but then in the order, as your lordship finds, there's an observation regarding the involvement of finance department and
A copy
eventually-
of will be also
Yes.
furnished to the Commissioner of Finance Department
And last
for
paragraph,
his notice so that once such proposal is submitted, necessary approval is given. So you'll obtain it. And the animal husbandry, where is Miss M.M. Kotuke? Ask her to come so that we obtain this instruction, why it has not been done. And after all, it's a pension or something, retirement benefits, no?
period salary, retirement.
This is an application file alleging willful and deliberate violation to the order dated 26/8/2025 in WPC number 6355/2023. Wherein the learned court, the bench of this court had disposed of the writ petition directing the director in animal husbandry and veterinary department to carry out the necessary action and file a fresh proposal for payment of the admitted arrears of salary and other retiral dues due to the legal heirs of the deceased government servant within a period of 4 weeks from the date of the said order, and thereafter duly assist the finance department for doing the needful. This court further, the learned coordinate bench had further directed the Commissioner and Secretary Finance Department, Government of Assam, to act promptly once the proposal is being submitted by the Director, Animal Husbandry and Veterinary Department, taking into account that the dues are pending, admitted dues are pending since 2020, and the said amount could not be released for non-receipt of FOC. This court, I have requested Ms. M. Kotoki, the learned standing counsel of the Veterinary Department of the Government of Assam, as well as Mr. P. Naik, the learned Additional Advocate General, as well as the Standing Counsel of the Finance Department, to apprise this court by taking instructions as to whether the order dated 26/8/2025 passed in WPC number 6355/2023 have been complied with or not. List this matter again on 11th of March 2026. Full copies of the instant application be served upon Ms. M.M. Kotoki and Mr. P. Naik, the learned counsels, during the course of the day so that they can obtain the necessary instructions as sought for. This court also directs the registry to indicate the names of Ms. M.M. Kotoki and Mr. P. Naik, the standing counsels of the Animal Husbandry and Veterinary Department, as well as the Finance Department, in the cause list. List the matter for motion on it. List accordingly for motion on the next date fixed herein above.
Final selection has been declared.
On 11/10.
11/10.
11/10/2025.
In the website, the final result of selection was declared. No list as such has been, Malad. If a candidate, he
The
enters the
final,
number,
it is the case of the petitioner that's a final result of the selection have been declared
declared.
in the website on 11/10/2025. As on date, there is still no select list published. And as such, the petitioners are also not aware as regards the cutoff mark. The counsel appearing on behalf of the petitioner further submitted that when the petitioners have searched as to in the website as to whether the petitioner have been selected or not. after providing their name as well as the roll number, what appears is that whether the particular candidate have been selected or not selected. The learned counsel appearing on behalf of the petitioner submits that recruitment to these posts fall within the ambit of Article 14 and Article 16 of the Constitution. Therefore, it is the mandate of law that such recruitment should be fair, transparent, which are fair, transparent, and without violating the equality clause. The learned counsel appearing on behalf of the petitioner further submitted that in a selection proceedings where the petitioners who appear, the candidates who appear, cannot even after inquiry, learn as to what marks the petitioners have obtained, as well as the selected candidates have been obtained. Under no circumstances can be said to be fair and transparent. And therefore, it violates the very mandate of Article 14 and 16 of the Constitution. Mr. Dinath, the materials on record show that though notice has not been issued, but since 1911-2025, instructions have been sought from the government as to what parameters have been followed. Today, when the matter is being taken up, Mr. Dinath, appearing on behalf of the respondent, submitted that though the advertisement was issued for filling up of 1645 post of Constable UP, 2300 post of Constable AB in the Assam Police and 1 post of Constable UB in APRO, but the said post so mentioned in the advertisement were tentative. He further submitted that various other litigations have also been filed in respect to the said recruitment process. And in that regard, reference was drawn to the order dated, the reference was drawn to WPC number 1902/2025 and WPC number 317572/2025. The learned counsel further submitted that the learned coordinate bench of this court, by passing an order dated 25/9/2025 in both the writ petitions, that is WPC number 1902/2025 and WPC number 3172/2025, directed the state not to effect any appointment against the post advertisement by the advertisement dated 6/10/2023. However, subsequent to an interlocutory application filed in IS Civil number 3284/2024-25, the learned coordinate bench of this court have modified the order dated 25/9/2025 on the basis of the submissions made by the learned Advocate General to the effect that 200 posts would be kept vacant. And it is in pursuance to that, a select list, the pursuance to that, the selection and appointments have been made in respect to 1571 post of Constable UB and 2172 post of Constable AB. The learned senior government advocate further submitted that there was no select list published, but what was done was notified in the website. In addition to that, it has also mentioned that 200 posts of constables have been kept vacant in pursuance to the order passed by this court dated 9/10/2025 in IS Civil number 3284/2025. This court have given an anxious consideration, and it is the opinion of this court that when applications are invited from eligible candidates and the candidates having participated, fairness in such recruitment process, fairness and transparency in such recruitment process mandates that the candidates should know what marks they have obtained vis-a-vis the persons who have been selected and appointed. Under such circumstances, this court therefore directs the state to bring on record by way of an affidavit the marks which the petitioners have obtained in the examinations in the said recruitment process, and assign the reason why the petitioners have not been selected. In addition to that, the affidavit shall also disclose the cut-off marks on the basis of which the candidates have been selected in various categories. The affidavit be filed by 12th of February 2026. List accordingly, along with WPC numbers 1902/2025, 3172/2025, and 1802/2025. Yes, Mr. Bora, what do you want?
Lordship, this petition is for promotion to the post of electrician to junior engineer, Lordship. The petitioner has filed several. rounds of-
Electrician to junior engineer.
Yes, Lordship, head electrician to the service rules does not provide the same. Therefore, I have challenged the service rules to the effect that no promotional avenue is there. Lordship. So the petitioner has worked for 30 long
So
years.
let it go to the division bench. You have challenged the service rule, isn't it?
Yes, Lordship. If Lordship comes to the prayers, Lordship, two
Ah,
prayers.
that is what.
Prayers are there.
How can I take it? It should be declared as service rule insofar as
Ma-
they
at
fail
this-
to
at
provide
this
any
stage,
promotional avenue, they shall not be declared unconstitutional.
That is one.
To notify the Assam so and so, 2015.
So far as the
That
second,
also I can't do.
so far as the second prayer is concerned, if Lordship comes to page number 47.
Yes.
Lordship, this is the order passed by the division bench, paragraph 11.
In respect of the petition.
Can be observed that if the REA have been formally the government as a model emblem may consider notifying the same to ease out the difficulties of REA.
So this is an unnecessary prayer, Lordship, so far as the second.
I can't do it.
And the first one is concerned, so far as this petition, prayer is concerned,
Hmm.
a rule is challenged, Lordship,
Hmm.
but the rule is not annexed. That is one, Lordship. And according to him, Lordship, entire rule is violative of Constitution, Lordship, Article 14 and 16.
Hmm.
So I think my friends should rectify this petition, Lordship, at least by annexing a copy of the rule, Lordship.
We can file an additional affidavit.
But how do I decide the constitutional validity of a rule? Let it go before the division bench. It has been submitted that the instant writ petition has been filed challenging the Assam Engineering Service Rules 1978. The virus of the Assam Engineering Service Rules 1978. On the ground that it violates the mandate, the fundamental rights under Article 14 and 16 of the Constitution. Was taking into account that as per the Guwahati High Court rules, a challenge to the virus of a rule, statutory rule, is to be listed before the division bench, comma, the registry shall do the needful. Mr. P. Nayak appears on behalf of which one?
All the respondents, Lordship.
All the respondents.
Obliged, Lordship.
My lord, this matter relates to the payment of family pension. My lord, friend of the petitioner died on 22/12/2019.
Why family pension not given? Daughter?
The first wife of the deceased also claimed the family pension.
Ah.
However, a member committee, 5-member committee has been constituted and asked the petitioner to bring the court charge. And accordingly, this petitioner has approached this honorable court and by filing a leave petition whereby this honorable court directed this petitioner to produce the order of the honorable court before the committee. But the committee has forwarded the matter to the judicial department of the government of Assam, follow the response number 1. And response number 1 has, after obtaining the opinion of the alert, has directed the response number 4, under whom the petition was working, and directed the response number 4 to pay the shares of the claimants accordingly. Stating that the divorced wife is not entitled to get the first wife, that is not entitled to get any family pension. So, as being the wife.
Yes, who is the respondent troubling the petitioner? You.
Madam.
Why?
Madam, because he has not made party to the first son of the first wife, madam. Lordship may issue notice, madam. I will take instruction, madam.
No,
Because
my
today's-
question is very specific. The petitioner herein
Madam.
admittedly is the wife.
Second wife, madam.
And
Madam.
wife, third
madam.
wife, whatever it may be, is the wife because of the fact that the earlier wife was divorced. So therefore, as per the family pension rules or whatever may be, you give the pension only to one person. Do you have the power, as per the rules, to bifurcate it?
No, madam.
That,
No.
why you're not paying it to the petitioner?
Kindly peruse the page 91, Lordship. The difficulty faced by the department that has been stated.
Yes.
Please say proposal to the second, first, that's to take on the parliament. Have a few problem.
The next are 50, whereby the respondent of again ask the opinion view from the respondent number one, and which was issued on 11.
Now, what is all these things? How can you delay the family pension which the petitioner is otherwise entitled to on the basis of these things?
Well, because my first son.
Isn't
has-
there a divorce decree?
No, my lord, first wife son is there, my lord. He has,
So what? Son is what is the age?
my lord, it is not mentioned here, minor, my lord.
Huh? How
Minor.
can the son come over out there and submit a minor? Tell me. See the language of the letter. He comes over in response to so and so, the wife of Iman. On the other hand, Amrit Sahu, son of late so and so, has not submitted the pension papers. Now, the first and foremost thing is that the wife will get it.
My lord.
Then
Issued on 11 December 2023, and thereafter I have.
what is your name? Sangeeta Sahu.
Yes, ma'am.
The decision be taken within a period of 1 month from the date of hearing. The petitioner may also produce a certified copy of the decision between the hearing and respondent and provide their copy. This is the second round of litigation.
My lord.
Then how many times the petitioner will come?
My lord may take it.
I am
out.
only issuing notice for only one purpose. To find out the officer who is responsible, who is going to pay the cost to the petitioner for all this litigation. You give me also file an additional affidavit how much fees you have taken and how much cost. So then we can impose it upon these two officers. After an order passed by the learned coordinate bench on 13/6/2022, after 4 years, this is the state of affairs. I have to now request, taking into account the plight of the petitioners or the persons who, because of the actions on the part of the department and the accountant general, and request the Chief Justice to again have the pension bench because of the fact that people are being seriously affected by the inactions. Where is the next of the Keen certificate?
My lord, at page, Annex 6 of page 42. One of some of the divorce wife is also a legal heir of the, no, I have no.
Your son is what?
My lord.
Huh? What is your son?
Mine-
Who are your sons?
I'm.
My lord.
You have two sons, no? Sons and
Yes, yes,
daughters.
two sons,
Who are?
3 and 4.
This daughter and for the son.
Yes, my lord.
That's yours. Okay.
They
Now
are-
kindly come, madam, kindly come to this. Amrit Sahu, 16. Do you see this?
My lord.
Now come to the date on which this is being registered,
2020, my lord. 22/6/2020.
which means 6 years have passed,
My lord.
22.
My lord.
Then is the son entitled to?
No, my lord.
That's state of affairs. Only for that purpose, huh?
My lord.
I'm fixing it on March. I'll come back.
My lord, on Friday, my lord, I'll take instruction, my lord.
Huh?
This Friday, my lord, I will take instruction.
Next Monday,
My lord.
issue notice. Making it returnable on 9/2/2026. Ms. So-and-so accepts notice on behalf of respondent numbers 1, 2, 3,
My lord, 3 I am not reviewing.
4. 4 also.
4 and 5, my lord. 3, my.
1, 2, 4 and 5. Pension 3 and 6. The petitioner herein, extra copies of the writ petition be served during the course of the day. Accepts notice on behalf so and so, yeah, accept. The petitioner herein, who is the wife of late Ramesh Sahu, who expired on
2019.
22/12/2019 in harness. He was in service, na?
Yeah, what?
In harness. Is aggrieved by the inaction on the part of the respondent authorities in finalizing the compassionate family pension, as well as the other retirement benefits, in spite of the fact that there is a direction passed by the learned coordinate bench of this court dated 13/6/2022 in WPC number 323/2022. Full stop. It's very pertinent to take note of that a perusal of the next of kin certificate, which is enclosed as Annexure 6 to the writ petition, dated 22/6/2020, clearly shows that the petitioner is the wife and the earlier wife of late Ramesh Sahu, one Sri Amrit Sahu, was aged 16 years. As on date, the said Amrit Sahu has already crossed, is already a major. This court now also finds it pertinent to take note of Rule 143 bracket 1 rule 143 of the Assam Services bracket pension rules 1969, which categorically shows that the wife has primacy in respect to the payment of the pension. This court fails to understand that even after passing of the order dated 13/6/2022 in WPC number so and so, the responding authorities have not granted the finalized the pension details, pension of the petitioner. First, the respondents, more particularly in the fishery department, as well as the office of the accountant general,
Will come into the picture only after.
the whatever may be. Earlier also you were there.
Comes only after the settlement.
Whatever may be, shall apprise this court why no pension, the pension as regards the petitioner have not been finalized, and also the officers who are responsible for non-finalization of the pension of the petitioner. List accordingly.
Only one line. I will take instruction whether papers has been sent to us.
Also responsible. No, then only you, both of you only come and say how much you have charged your client. So that amount will please.
How would we come only after this?
So therefore, it is your responsibility also to look into it. You will say that. Yes, Mr. Sharma, what are you asking? Transfer
Yes, madam.
to the post of assistant so and so. The impugn notification dated 16. Where is that notification?
Page 40, ma'am.
Huh?
Page 40.
Page?
Page 40, ma'am.
14?
No, ma'am.
40.
Oh, 40. In the interest of Raju Gopal, who is he? Junior principal ITI so-and-so is transferred and posted as assistant director of so-and-so with immediate effect against existing vacancy. Junior principal Leah is thereby allowed to hold charge of ITI along with ITI in addition to his substantive post of immediate effect until further orders. Yes, tell me.
Yes, well, factual metrics of this matter is that, my lord, on, my lord, February 2024, my lord, page 22. Page 22, my lord. I have been transferred from Bongaigaon to Maratin Shukla.
Okay.
One of the 1, 2, 3, 4, my lord, in the interest of public service, insurance, junior principal ITI, Bongaigaon is hereby transferred and posted as junior principal ITI in Shukla with immediate effect, against existing vacancy. Then, my lord, what happened, my lord? My lord, as my lord, earlier, and accordingly, my lord, I had.
Where is this Directorate of Employment and
Skill
Craftsmen?
Employment and Entrepreneurship Department.
Where is this? You are transferred to which place?
From Bongaigaon to Tinsukia.
No. Now you are transferred to where?
Guwahati.
Guwahati, Lordship.
You have your permanent resident
Yes.
in Guwahati. What is your problem?
True, my sir. But, my lord,
Then you should be happy.
no, my lord, it's true. But,
Somebody who doesn't want to come to permanent resident, do you have some family feud? Then
But, my lord, what happened in this case, my lord? As my lord, I have approached this honorable court, my lord, that, my lord, asserting that, my lord, that my grievances, my lord, by way of, my lord, petition, my lord, and notice has already been issued on that matter, my lord. This transfer has been issued in the punitive nature.
why?
Yes, my lord.
What did you challenge earlier?
My lord, that, my lord, we have challenged that, my lord, that charge has not been handed over to me, my lord. That's why, my lord.
At ITI?
Yes, well, ITI, ITI, my lord, should care, my lord. So if you kindly put annexer C, page 27, my lord. Kindly see. One communication by the, my lord, accountant general, my lord. Page 27, my lord.
Issue of transfer director here, you are hereby requested to instruct here junior principal for submission of letter or in case of special order relief. So you were transferred from Bongaigaon to Tinsukia, but
But, my
you
lord,
did not furnish the handing and taking over charge reports without putting the signature of the relieving and relief officer. So therefore, you are asked to submit a fresh report.
Yes.
You challenge this.
no, my lord, then, that's why, my lord, I have failed to submit my lord. But
Ah.
then subsequently, my lord, page 30, my lord.
Hmm.
One communication is made by the joint director to the concerned officer, my lord, that is Moniram Das, the superintendent. And is that response number 4 in this petition.
Sign the child.
Yeah, I did, my lord.
This is given to some Mani Ram Das.
Yes, my lord.
Then
Lord, kindly see last paragraph, my lord.
only you are
In this
instructed to
context, as per
adhere
the
strictly to
communication.
the laid down procedure to hand over charge. Hand over charge where?
At Tinsukia.
Okay. So he did not hand over the
Yes,
charge to you.
Yes. And that's why, my lord, that, my lord, accountant failed to issue that, my lord, pay slip to me, my lord.
Then
Being agreed, my lord, I approached this honorable court, my lord, and must kindly page 32, my lord.
what is your challenge? Why did you approach?
My lord, for direction, my lord, to, my lord, my lord, to the, guiding the respondent authority to do the needful regarding, my lord, charges and the over of the charge, my lord. So,
By the private respondent, this
Yes.
person, Moniram something.
yes, my
Moniram Das.
32 now, that notice has been issued, my lord. Matter has been fixed on 20.
Moniram Das. Okay, then?
Then, my lord, when this matter was pending, my lord,
Hmm.
then subsequently, in the main lord, my lord, I have been engaged as zonal officer also in the election department, my lord. Then, my lord, this impugn order has been issued.
So you have been put
And
from
my lord,
Tinsukia to Craftsman at Guwahati.
Yes, and my lord, my lord, that Moniram that has been, my lord, given the charge of, my lord, temporary charge, and then, my lord, principal of ITI in Shukia, my lord.
same person. My lord.
Now, till now, but you don't have the charge of Tinsukia.
Yes, my lord. Formal charge, my.
So therefore, how does it matter?
I have not.
You should be happy. Isn't it?
Yes.
But I
You are fighting for not handing over the charge. Now they say that okay, don't fight.
Come to
We
your.
have some love for this Moniram Das, and therefore this Moniram Das is not only given the responsibility for ITI Jorhat, but we give it for ITI Tinsukia, Lahual, and Naharkotia.
Additional charge.
And in addition to his charge, so he will have the entire control. And therefore, what is his name? The skill director, secretary to the government skill development and entrepreneurship department.
And my lord, Jorhat, from Jorhat.
So
to my-
therefore, she likes this person, Maniram Das.
And my lord, 106 kilometers away from my lord, Jorhat to my lord, Dibrugarh, my lord.
Ah.
Tinsukia, almost my lord, 180 kilometers away, my lord.
The roads are good now.
Lords are good. Good lordship.
No problem.
Only 2 hours, 2.5 hours.
You stay at your permanent residence here.
2 months. But my humble submission, my lord, this paper is not issued in my lord public interest, my lord. Only to accommodate the respondent number 4, my lord.
No, you were not given a charge since 2024.
Yes.
Since to that, for which you had to compel to file a writ petition, engage a counsel, pay out of your pocket some amount. Now they said, okay, don't fight amongst yourself. You go to Guwahati, be happy there. So what is wrong?
My lord, my lord,
What is your love for Tinsukia? Tell me. Is this punitive means your post is put somewhere down?
no, my lord, rank is same, my lord.
Same.
What is that?
But my lord,
In fact, you should also pray that I want to withdraw this petition along with the other one. Also.
Under with yes, lords.
keep my-
Okay, we'll have the other one on some other day to say that it has become infructuous.
otherwise, my lord, if my lord, if one was
I would have understood you are there. You have not got your charge from 2024, for which you had to file a writ petition. Then, no case.
my lord, if lordship, that discourage this.
If you now I issue a notice here, what punitive measures they may further take, then you don't know. But where is the question of stay? What do I stay? Tell me. Means you don't want to work because you don't have a charge from 2024 there. And if you are brought here, you will have to work. Tell me, are you getting your salary or not?
My lord, not regularly.
But you are getting your salary. So therefore, but without work.
No, I'm working, man.
How?
No, I am working.
Why did you file the writ petition earlier?
But my lord, the formal charge not handed over, man.
Understood. That means he is also working.
No,
Who is working there?
I'm working. I am working.
Then why did you file the writ petition?
Because my lord, as the accountant general, office of the accountant general has not issued the my lord pay slip, my lord.
Because of that, that is the problem. They were settling it. You be at home. You have your permanent resident here. You say in your petition also.
If my lord authority has my lord treated me, my lord, discriminated way.
But I don't think this is a case of stay. Stay doesn't arise. So if I issue notice again, the same thing is going to happen.
And my lord, I have submitted my representation also, my lord, that is also pending, my lord.
You consider it, but I don't think it's a good case. If they submitted the representation, then should I pass an order here? You consider it.
Yes, lords.
Because if I pass an order, then your department, who has certain fondness for that Maniram Das, could get more punitive against him.
My lord, that my lord, that Muniram Das, my lord, not on, my lord, he is my lord, holding the four IPIs, my lord, now.
All are nearby, na? Naharpati,
Yes.
everything. No, therefore I'm saying they have an affection to that person concerned.
But my lord, in the end, so much affection is sometimes, my lord, in the expense of myself, my lord, very bad, my lord.
Yes, Mr. Goswami, what do you say? If I issue notice, I'll state. But the reason is, first of all, this person has been asked by your department to hand over the charge by 2-3 documents. He does not hand over the charge. And because of that, the petitioner is suffering and he has not got anything. Now, what you do is, instead of being more strict with that fellow, this Boniram Das, you give him an additional charge.
What is the background, Lordship? I have to take the
Yes,
instruction.
that which doesn't seems to be good. Because why is it necessary for this ITI thing? You have a post. Giving him an additional post, why is it necessary? Tell me. Are you not, is it discipline in your office? Let's not go into the question of punitive, but on administrative exigency, I would have understood you are bringing somebody else as a permanently there. But no, you're giving him an additional charge. Why?
I have to take the instruction, Lordship.
Your thing is that we'll have it next week.
Lordship.
Stay. Issue notice making it returnable on 13th of February 2026. Mr. So-and-so accepts notice on behalf of the respondent numbers 1, 2, and 3. As regards the respondent number 4, the petitioner shall take steps by tomorrow, by way of speed post. In addition to that, the petitioner shall also effect service upon the respondent number 4 by way of dusty rotatory registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner was transferred by an order dated 26/2/2024 from ITI Bongaigaon to ITI Tinsukia. Full stop. The petitioner, when he joined in ITI Tinsukia, was not provided the formal handing over charge by the respondent number 4. And this aspect is apparent from Annexure C and Annexure D to the writ petition, wherein specific directions were given to the respondent number 4 to formally hand over the charge. Full stop. Annexure C, D, and E. Full stop. The non-formal handing over of the charge by the respondent number 4 created a lot of difficulties for the petitioner to get his pay. And resultantly, the petitioner was compelled to approach this court by filing a writ petition being WPC number 7184/2025. This court issued a notice by an order dated 15/12/2025. The respondents, more particularly, the respondent number 1, instead of taking appropriate steps against the respondent number 4, instead transferred the petitioner to the office of the Directorate of Employment and Craftsman Training, Assam, at Guwahati, and thereby giving additional charge to the respondent number 4, in addition to his substantive charge as Junior Principal ITI Jorhat, an additional charge of ITI Lahual and Naharkoti, ITI Naharkotia. Was taking into account the materials on record, it does not, it prima facie appears that the transfer of the petitioner from the post of ITI, from the post of junior principal, ITI Tinsukia, to the post of Assistant Director of Craftsmen and Training, Office of the Directorate of Employment and Craftsmen Training, Assam, not to be in public interest, rather to accommodate the respondent number 4. This court further fails to understand the reason behind the respondent number 4 being given an additional charge of ITI Tinsukia, in spite of the fact that by communications which have been enclosed as annexes C, D, and E, the very respondents have instructed the respondent number 4 to hand over the charge. Considering the above, this court, till the next date, stays the notification dated 6/1/2026. 16/1. 16/1/2026.
6/13. 6/13.
13/13/13.
13, 13/2. 13/2.
Oh, yes.
Yes, of course.
Transfer matter. We have to dismiss it on that day.
Of course.
Yes. Oh, your bad case. That day only I wanted to dismiss.
They are the Anganwadi workers, and in addition to that, they were engaged as PLO.
Huh?
They are Anganwadi workers.
Understood. You want to be the boot level officer. Bad case.
Government has decided to not to work and engage Anganwadi
No,
workers
you don't have right.
outside the ICDS protection.
And in fact, it affects the ICDS portal.
Not.
ICDS, no? ICDS. Yes.
The grievance is that lordship. Here lordship, the notification issued in case of Morigao lordship. In the nearby district Nogao, till date lordship, the Anganwadi workers are continuing as in here.
He has not challenged this order, lordship. Now he is agitated, lordship, but he has not challenged this order, lordship.
Which order?
This 12/8/25, lordship, annexer H, lordship. And government has decided, lordship, on 15/6/24, lordship. Kindly see the reference letter.
I know. Problem is, why haven't you make the chief electoral officer party? The election officer has no business out there. It's too small a fry out there. The main is the chief electoral officer as to whether it is their decision to do so. And it is the social welfare department also. Would they like to spare these Anganwadi workers?
Lordship.
Would you
Government-
like to spare your Anganwadi workers and helpers to the post of boot level officers? Wouldn't that affect your working out there in the ICDS project?
Lordship, on 15/6/24, lordship, government has decided not to work the Anganwadi workers, lordship.
Where?
Kindly see the annexer H, lordship. Reference letter number, lordship. Letter received from Women and Child Development, lordship, and subject complaints of the instruction regarding non-engagement of Anganwadi
You have
workers.
that copy of that letter?
No, lordship, that was not received, lordship.
You get a copy of this
Lordship,
order. We'll
we'll
have
obtain,
it on
lordship.
next Monday.
Lordship, will obtain, lordship.
You get a copy of
Lordship,
this. order.
we'll
I'm not putting it out here.
Lordship.
Just have a
On the next day, will obtain, lordship.
15/6/2020.
Lordship.
On that day, we'll close it.
Obliged,
This is the matter on 9/2/2020.
obliged, lordship.
Make your lordship.
Yes.
My lord, the petitioner before lordship, they are grade 3 and grade 4 employees, my lord, 16 and above lordship.
The person in advertisement for a regular selection, my lord, they were selected, but they were appointed, my lord, on contractual basis, because my lord, at that relevant point of time, there was no sanction. And my lord, there was an assurance that my lord, on sanction, those posts will be regularized. Now, the advertisement was of 2011, they were recruited in 2013. And thereafter, my lord, although they received salaries for up to 2015, then till 25, they did not receive their salary, my lord. For 10 years, they did not receive salary. Then, my lord, they started paying salary again in 2000, my lord, October. Now, my lord, what happened? Now there is a move to, my lord, sanction some posts. Some proposal has been sent by the, my lord, the council to the government. There, my lord, they have indicated only 7 numbers of posts for group, my lord, group 3 and group 4. So if that happens, my lord, all these petitioners may lose their, my lord, job, number one. And secondly, my lord, there is no parameters laid down forward appointed at the same, same point of time. How they will select these 7 persons? Because they were appointed person to the same advertisement. If your worship kindly comes to the advertisement, which is at page 23, your worship will see the terms and conditions there, my lord.
So what do you want now?
Now, my lord, your worship will issue notice, my lord, let them respond. But in the meantime, my lord, there is an apprehension that they may go ahead with the sanctioning of 7 posts only. So, my lord, these petitioners may lose their job also, my lord.
Huh?
These petitioners may lose their job also.
Why?
Because, my lord, if 7 posts are sanctioned against this, my lord, the petitioners are, my lord, 16, my lord, then, my lord, they'll select. We don't know, my lord, what will be the model list of selection. They'll select, my lord, 7 persons and others will do the job. We do not know, my lord, who will do the job.
If they create those posts, they may regularize you also.
No, but the proposal they have sent for, my lord, creation of only 7 posts for group 3 and group 4.
So what do you want now?
My lord, either that proposal may be stayed, or, my lord, they should not be disturbed from their service till they may not reform.
That type of order is not possible.
At least then your worship will stay that order, my lord. Why they have issued only, my lord, the proposal, they have signed only for.
Absolutely no. Why should I? It is not my business to look into all these things. Let them create posts. If the posts are being created, then you participate. And if you can't participate, they may create posts for the purpose of regularizing also. You never know. How do you know?
If your worship kindly comes to the advertisement, my lord, what is stated there in the
Yes.
page 23, my lord.
Ah.
This is, my lord, issued by the Principal Secretary, Deori Autonomous Council. Applications are invited from Indian citizens. Then your worship will find, my lord, senior assistant 3 numbers, junior assistant 12 numbers, grade 4 22 numbers, driver 2 numbers. If your worship kindly comes to the last but one paragraph, eligible candidates for the post of senior assistant and junior assistant may have to appear in written test, interview, computer, etc. No TDA will be admissible. Then, my lord, no post in different number of posts in different categories may be increased or decreased. Salary will be given on fixed pay basis as approved by the council till the posts are sanctioned by the government. Therefore, my lord, there is an assurance or some kind of promise that, my lord, these posts will be sanctioned. And there was a selection, my lord. On the basis of this selection, my lord, they got their appointment orders.
So
now, my lord, now they are sending proposal for only 7.
So you want more?
Yes, my lord, all the petitioners should be covered by that proposal. Because the reason for, my lord, giving this, my lord, they
So
require.
the question therefore of stay does not arise. If you want more posts to be put to sanction.
The other way of looking at it is, my lord, if 7 posts are sanctioned and, my lord, the 7 posts.
Creation of posts is a very important factor, which the government is doing. It is good, but the fact that you have a right in respect to those 7 posts having been created to be regularized is another aspect, which will be seen only when the 7 posts are created. Why should this court now take into account these aspects?
My submission to your lordship is that, my lord, in the advertisement, he have given some conditions, my lord, that, my lord, till the sanctioning, you'll be given a fixed fee scale. Meaning thereby that persons who have been appointed, there is a requirement of these persons, my lord. Had there been no requirement, my lord, the service would not have been taken for the last 13 years.
So therefore, the necessity is that the government should sanction posts.
Yes.
So if they sanction those posts, then those posts are, you are not accommodated with them, then it is a different aspect of the matter. But how do you come now at a stage when there is a proposal for sanctioning? Post has not yet been sanctioned. Whether the finance would sanction or not, that is a very big thing. No case. No notice.
No, my submission to your lordship is, my lord, if they, my lord, send the proposal for sanction,
Once the posts are being created, then you have a right of regularization on the basis of this advertisement is another aspect of the matter. On those sanctions, because you have to be regularized where? In respect to sanction posts. The post is bigger. Now 7 is being sanctioned. Against that, you have a right to be regularized.
true, my lord.
But now it's a proposal for that. What right do you have?
No, my question, my lord, my
It's a
submission.
different thing. You may ask that there should be more posts which should be regularized, sanctioned, so that we can also be accommodated.
True, my lord. Your worship is right, my lord. But the apprehension is that, my lord, if 7 number of posts are sanctioned, and my lord, naturally, they created, my lord, created and sanctioned. Naturally, my lord, 7 persons out of these persons will be, my lord, accommodated there. There has to be some yardstick on the basis of which, my lord, they will select this person, the petitioners. Some of them may be accommodated, some of them may not be, will not be accommodated.
So therefore, your request should be, the thing is, there should be that not only 7, 22 posts.
That is my prayer, ma. That is
should
my
be.
final prayer.
Where is your prayer?
Prayer, your worship is fine.
Where?
At these 19.
Yes, where is the post?
Prayer 1.
To create and sanction the post held by the petitioners who were selected and appointed pursuant to the advertisement from the date of the initial engagement. There?
That is my final prayer.
So therefore, that prayer is contrary to your interim prayer.
Apprehension is about losing job.
No, you losing job will soon later on. First, let them create the post.
The different cause of losing job. And I believe, my lord, this is the immature, my lord. We are yet to sanction. create the post.
My lord, I am appealing for the council, my lord. Already, my lord, 15 posts are sanctioned. I have placed before lordship, my lord. For Delhi Autonomous Council, DAC, my lord, 18 posts. Out of, my lord, this 15 posts, my lord, 9 posts up to junior engineer, serial number 9. It will come fill up through deputation. Then, my lord, LDA through promotion, AUDA through 1 post promotion, LDA 3 posts, direct recruitment, accountant 1 post promotion, and grade 4 peon, the 2 posts, my lord, direct recruitment. Subsequently, my lord, a meeting was held, my lord, I placed on 24/6/2025 amongst the, my lord, their association that I have placed in the, my lord, Prostab number 1, my lord. 1, 4, 4, and go, my lord. Deuri সাহিত্য সাহিত্য পৰিষদে যিসকল কৰ্মচাৰীক হিচাপে নিযুক্তি দিব নোৱাৰে সেইসকল কৰ্মচাৰীৰ চাকৰি অসম চৰকাৰৰ নিৰ্ধাৰিত হাৰত ফিক্স পে বেচিছত পৰিষদে নিজাববীয়াকৈ দৰমহা দি বাহাল ৰাখিব লাগে. This is the demand. Subsequently, my lord, council in the general meeting of the general council meeting, my lord, held on 14th August 2025. Here it is the, my lord, resolution number 8, my lord, postam number 8, my lord. We have taken a positive steps, my lord.
Where?
It is, my lord, postam number 8, my lord.
I have till 6.
No, my lord. Another resolution of the, my lord, general council of the.
Okay. 8.
Postam number 8.
What is this? So your thing is whomever can be accommodated in respect to the sanction post, they will be removed.
As per my
And
seniority.
those who cannot be accommodated.
For
they
that,
will
my
be-
lord, we will make proposal
Uh,
for sanctioning another post. my lord.
So.
Because
other-
already-
Other persons, they will be continued to remain.
Continue, my lord. They will not, they will be allowed to continue, my lord. They will get the, my lord, pay, my lord. That is our
They will get the fixed pay.
fixed pay, my lord. From October, I think they are regularly getting the total 25, my lord. Now they are regularly getting. We have also made the proposal for sanction of the earlier period, my lord. That
Now
is-
he is also asking for areas.
areas, we have made the proposal, my lord, page 50, my lord, lordship kindly see.
Uh,
Page 50 in the read petition, my lord. These are, my lord, not yet released, my lord. Allocated, my lord, some, these funds are withheld by the government. That is,
But the fact remains that these people are working.
working, my lord, they will,
And
we
therefore they are
accommodate, my lord.
entitled to.
We are taking steps to, my lord, create posts.
So they have a legitimate expectation to
Yes,
be appointed against regularization.
regulation, my lord. So we are not going to throw them out, my lord. Then, my lord, lordship may record in the order, my lord. We are taking steps, my lord, to accommodate all the
Okay,
persons they are working,
we issue notice
My lord.
now.
my lord.
Mr. Chaudhary, I think you need to improve your pleadings in terms of the recent judgment passed by 2-3 days back by the Supreme Court in the case of Bholanath. Have a look at it. Your case, you can bring it exactly within it. Wherein it say, although Uma Devi says about legitimate expectation, a person who have been selected by way of a proper process, they have a legitimate expectation. Develop your, by filing an additional affidavit, so that it is a case where we can grant regularization. Don't ask for stay of regard, because if you ask for stay, you are putting on hold. Getting posts regularized or creation of posts which they want on sanction is the necessity. And they have been also accommodating those persons already who have been, whenever the posts are there. And therefore, their stand is, whoever have not yet been accommodated, they would be kept in the fixed pay basis till proposals are for sanctioning is being done. Now, if we stall it, it would be not only in your interest, but it will be also in the interest of creating posts also. Yeah. Let's issue notice on the aspect pertaining to the area pay and how do you take the, then the government is there.
Government is there, my lord.
So here the government have been made a party.
Yes.
Commissioner and Secretary, WPT and BC Department.
Now, how is the payment to be made and why you are making the WPT and BC department? That department has gone for a 6, isn't it? Is there department there?
Yes. My lord, yeah, number 2, they have made secretary a party, tribal affairs. But my lord, I understand their finance is also essential party, because at the end of the day,
Finance is there and you see the WPC BT department is not there.
not there.
So therefore it is the tribal affairs department.
Tribal, they do 9 department.
Social empowerment.
You do one thing, Mr. Chaudhary, why don't you file a fresh one and bring on record this judgment, take on record this thing and bring something on here, better. Because these parties are not there, and make the finance also a party.
Finance is very essential.
And have a look at these also, which may help you in formulating your petition. Take this judgment, and more particularly, the judgment this is delivered on 30th of January. Okay. Have a look at this judgment, and more particularly paragraph number. This paragraph may help you a lot in your case. Paragraph 13. Bholanath versus State of Jharkhand and others. This is a better, means a more refined judgment than the, it is after all following the same judgments, Jagu, Sirbal and all. This further brings in the aspect of legitimate expectation. And your case will come within it. And these documents may also help you out. This, I think I'll keep it. Okay. Mr. M.K. Chaudhary, the learned senior counsel assisted by so-and-so submits that taking into account that the petitioner respondent number 1 have been wrongly narrated and the finance department is not made a party. The petitioner and further certain additional informations have been received by the petitioner would like to file an additional affidavit by making those formal corrections and also incorporating additional facts. Those facts may be relevant. So taking into account the above, the writ petition stands closed on withdrawal, liberty given to the petitioner to file afresh. What is this?
58, 59 and 60 are similar. Matter regarding recovery of bricks and facts.
Oh, same order I passed, na? I fixed it on 11.5.
22.5. 22.5.
22.5? No. See, first page, issue notice. Issue notice, first line.
8 what?
Huh? Eh,
11.5.
and then
Yes.
I tell you, no. The same order.
59, 60.
I'm for 58, man. I'm for 59, 50.
Updated item 63.
Your Lordship, instructions were called for your Lordship.
Yes, what is this? He wants the transfer from
Milo. But there was a public complaint.
BPHC Somota to BPHC Mukalmua. And it has been transferred from Mukalmua to here. I'm going to state it. It can't be. You see, first of all, if somebody is discharging his duty, some people may don't like. Can you transfer him?
No, it's not a transfer. Temporarily, it has been, my lord, this arrangement has been made, temporary arrangement, and it is within the same district.
So what? It's not the question of that. He has been transferred to the.
Temporary
Let's
basis,
see
I
the
think,
order of transfer. It's an order.
Page 19.
He is hereby transferred.
On
This is the
temporary
order,
basis.
1411.
On temporary basis until further.
On temporary basis only. You always do on temporary basis only everything. But he is transferred.
Well, I leave it to my.
No, the
but, my lord,
reason
the
why
main
I'm
reason
saying
is-
so, this is, you see, how a person would be in a position to work properly. If a complaint is being made, now what is the complaint here?
He is
Amar
not
Binodini
treating
Bedin
the
Logo
people
so and
well.
so, so and so, what?
Patient and
ৰোগীৰ
attendant,
প্ৰতিগৰাকীৰ লগত
they lodge
তেওঁৰ
the complaint.
সেৱা আৰু ব্যৱহাৰ প্ৰতি- Now, if he has a huge problem as regards interaction with the patient, would he be good in the other place?
Yes. My lord, that I understand. If there is a.
Therefore, you can't transfer him. There's some problem with that, take disciplinary action against him, but you can't send a transfer. And more so at the hands of the minister.
That my lord is possible, my lord. We have got judgments of the division bench. That my lord, the departmental minister, of course, he can recommend for transfer. Departmental minister, he can of course, my lord, recommend for transfer. Provided my lord some public.
This is not a
complaints are received.
recommendation, as per the direction
direction,
received
that's
from
why.
so and so, he's put
Of course he can, my
on
lord.
further
In
direction.
greater public interest, he can, my lord. These are settled law, my lord, of the division bench, my lord. He can, even my lord, on request of MLS, my lord. Then also, my lord, it can be made. That cannot be said that, my lord, because of political.
No, a recommendation is being made. We consider the recommendation. No, it cannot be a direction. Look here, it cannot be a direction of the minister. It can be a recommendation. They look at recommendation, and we have looked into various other aspects, and therefore we found that yes, it is justified. Then it is okay. Because he being a public representative, he can very well say so.
Yes.
There's no problem with
Of
that.
course.
But the fact that it can be only a recommendation. But because of his direction solely, without looking on anything else.
Records will reveal, my lord, what is his recommendation or the direction, it will be there in the record. I could not collect this particular page only. I will place it, my lord.
I'm sitting aside now.
No, let me file the affidavit, my lord. That is, lordship is going to.
Let me see.
Lordship will give me some time, I will place it.
Have you joined? Has the other person joined? What about the other side? Has he joined me?
That, my lord, I don't have the instructions from him. Because, my lord, if he has joined, my lord, again the issue will be a salary part, my lord.
Huh?
Salary will be, my lord, the problem.
That will be a
Two
problem.
person in the same post, then again.
Let's have it on Wednesday. You
Yes, I
just
will
get
have the
an
clarification.
instruction.
Yes.
An instruction has been placed before the court by Mr. B. Gogoi, which is kept on record and marked with the letter X. A copy thereof is also furnished to Ms. So-and-so, who appears on behalf of the petitioner. This court inquired with the learned council, standing council of the National Health Mission as to whether the transfer order which have been impugned in the instant proceeding have been given effect to.
Well.
Full stop. Mr. B. Gogoi, the Learned Standing Council, submits that he will obtain instructions in that regard. List this matter on 4th of February 2026. By admission. Oh, service line comment. Admission area. Yes. What is this?
My lord, this matter pertains to my lord, family pension.
What happened?
The petitioner was my lord appointed as a my lord MR in the year my lord 1988. Thereafter, his post was regularized on 23/5/2003, my lord, at page 15. And subsequently, after 1 month, he died, my lord. He died in harness, my lord.
Petitioner died.
Yes, the husband of the petitioner.
Now?
Now the wife of the my lord, Monilal Das has my lord approached this honor report for family pension.
So you're asking for family pension as well as ADS, taking into account that you were a master roll worker. And when he is regularized, only 6 years is taken out. What is it?
No, my lord, it was regularized, my lord, from 23/5/2003.
23.
5/2003, after 15 years of, my lord, 15 years, 5 months, continuous service.
And 23/5/2003. 26 weeks. What is the date of regularization?
Regulation is at page 15, my lord, 23/5/2003, my lord.
Where is that order?
Page 15, my lord, Annex 1.
Only learn so and so is upgraded to the post of regular chokidar in the scale with effect from so and so. How is the executive engineer doing that? Huh? Yes, who is paying for the government? Can the executive engineer regularize somebody? When did you retire?
I dying highest minor on 25/6/2003. Altogether, he served for minor 15 years, 5 months minor continuous service,
15 years?
5 months.
You have worked.
Yes.
Then family pension thing is moving. Then what happened? Why you have not been granted?
Yes, not done.
Let's see the service book.
Sorry.
Uh,
Case 38 minor.
21.
The original one is at page minor 43 now.
So date of birth 5 years, date of service book prepared on 7/3.
पेंशन कितने के दिया सर? पेंशन दिया हुआ है? Are you a regular employee? Regular? I think I want to wait for that. I want to wait for that. ऐसा लगा अगर काम तो की नहीं एवरी कंपनी इट अपीयर्स टू बी वेरी मच एक्शन and I'm not going to. मेरा आपका दिमाग है it's really it's your responsibility.
How do you bring the master role workers thing out here? Yes, Mr. Nayak, what type of regularization is this? How is the executive engineer
Yes,
doing it?
only the executive engineer regularizes
And that's
service.
to upgrade it as so and so against vacant post.
Yes. So without any approval of the state government authority, Lordship. But in this case, Lordship, Dimahasa or PWD has already forwarded the pension papers in respect of the petitioner to the office of the, AG, Lordship. They have returned the file, Lordship.
Why? No, the question is, if he is a master roll worker, whether his previous service can be taken into account.
If regularized, there is a notification, Lord. That Sanjita Ray judgment is there, Lordship. The prior service prior to regularization has to be calculated for the purpose of qualifying period, Lordship. That is another issue, Lordship. First, Lordship will have to decide, I think, whether his regularization was correct or not, Lordship.
That's it. Because
That is the-
whether, how can you regulate like this by the executive engineer?
Yes.
Why no affidavit has been filed by anybody? On the other hand, the respondent, the Dimahaso, some respondent has filed an affidavit saying that he regularized. Who is this? The respondent number 2. Executive engineer PWD Haflong division. At paragraph number 5. The deponent says the petitioner husband died on so and so when he was in due course of his regularization in service. His service was regularized on 23/5/2003.
And if Lordship comes to page 46, Lordship.
46.
Yes, Lordship, this is part of the service book, Lordship.
Yes.
This is handwritten. Lordship may kindly see the fourth letter. This is regular Chokidar, and scale is mentioned.
Huh? Services brought under the regular Chokidar.
Yes.
What do we do with this?
Because I have asked daytime only, because we filed once in 2022. The pension fund not been received some irregularity, not, I mean to say not in correction. That is we have thereafter. I again inquired daytime that whenever they have to obviously told me that 23, we have returned with some due to some regulation anomalies or something. But I tried to bring it that later, that office today is giving it to man for study not available. They have to only 1 day or 2 days accommodation so that I can bring the facts why we set back. Because unless we have to do ultimately this sanction we have to do. So,
Question is, can he be said to be regularized in this manner?
that question is regularized only
By the
if
executive
it's there,
engineer?
Mr.
Can he do it? My only
Executive
question,
engineer of his own, he cannot regularize service of any worker, Lordship.
unless the
Unless the-
Dimahasao, you are Dimahasao. Unless the Dimahasao executive council categorically says so. But then also a creation of a post out there.
This is necessary. But even if his service is considered to have been regularized, Lordship, from 88 to 2003, it is around 15 years, Lordship. Even if the master.
15 years, if it is taken, then he gets it on a proportionate basis.
Yes.
In view of 140.
No, he will not get proportionate also in that situation, Lordship, qualifying period is 20 years.
Huh?
20 years. Lord.
Where is it 20 years?
No.
Let's see 20 years. Where is it? 138?
Lordship, there is a notification, Lordship, it was first in 1996. Then 2003, it has again been clarified, Lordship.
What?
For temporary employees without confirmation, their requirement is 20 years. One notification of
But he is regularized.
regularized, but service could not be confirmed, Lordship.
But he died in harness. So then by notification, another notification, when a person has 7 years of service, he gets the pension. If he dies in
No,
harness.
that is for regular appointment, Lordship.
So therefore he is regular.
No, his service, even if this regularization is considered to be correct, Lordship, his regularization was in 2003. May 2003, and he died in June 2003. So this entire period from initial appointment as master or lordship till his death, it is 15 years. Pension fund assignment. Family pension. তাতো 1 বছর লাগে 1 বছর হলে 1 বছর নাই 2 মাহ 1 মাহ
Where is that section?
One,
108.
108.
108, I think that is 10 years, Lordship.
Now, after a service of less than 10 years, gratuity and not exceeding except in special cases so and so. After a service of not less than 10 years, a pension not exceeding the following amounts.
10 years for regular employment, Lordship. If a person is holding a substantive post, in that situation, it is 10 years.
No, in view of therefore the Sanjita Roy, it says that a person who has been already regularized, he gets back the benefit of those 15 years of service.
Yes.
Then why won't he come under 180, 180?
No, Lordship, here his initial appointment 1988, died in 2003. So it is total period is 15 years.
15 years,
12
okay,
plus.
but why wouldn't he be, if the benefit of Sanjita
No,
Roy
no,
is,
in his case, Lordship, to be eligible for promotion, pension, Lordship, the qualifying period is 20 years. Because he is a temporary employee. His regularization was against a temporary post.
his regularization is against a sanctioned post.
Sanction for the purpose of regularization, Lordship, that post must have been created, Lordship.
No, against the sanctioned post. That is the word used in the regulation. You are therefore referring to this particular document, this another, where is the document? This book is also repeatedly typed out, how it's made.
Two 2003 con খুলেগো আছে বলে তো জানি এটা আছে কোন
Yeah. In continuation of the department's dated 93, it reiterated that the said OM clearly says that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits
20 years.
without being confirmed.
Yes.
The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is superannuated or incapacitated or dead,
Temporary employee
is not the
acceptance.
moot point. Any confusion in that regard is so and so. So this is the notification of 2003.
Yes, this notification we apply in case of those whose services were regularized in 1995 as well as in 2005. So all those 30,000 of earlier, it was around 10,000, 20,000 Lordship are getting pension on the basis of this notification only. Because for the purpose of regularization, these posts were created against their name.
To determine the
At a temporary
continuous
employee, we can
service of the
separate us.
person as a master worker and if such line meets the benchmark of 20 years without any deduction, benefit of pension. Okay, now kindly come to Sanjita Roy, paragraph 31.
Not centers of temporary employee.
Paragraph 31, last paragraph. How do you take care of this?
There is another my lord, office memorandum dated 31st July 2010, my lord.
Where is that? Page
380, my lord.
of which book? 318.
380.
3,
80.
380. Hmm. Yes.
Counting of past services of master workers towards pension. Consider upon the decision regarding counting of past services of the master workers towards pension by OM dated 20th May 2009 and number dated 18/3/2010, the account general Assam dated have raised certain points for further clarification regarding the rate of effect of the pensionary benefit and the decision which the period of master services prior to regulation will be verified. In case of regular master roll worker appointed against sanction, they can post part of their past master roll services prior to regulation are to be counted for the purpose of pension in terms of TC Department of Oral Budget 25/2009 on attaining the election appointment by the regular master roll worker. And fourth paragraph. Further, the government of PNPG department is aware of the settlement of pension cases of the regular master worker prior to issuance of the department of is at 25/2009. If pensions cases of such regularized master workers prior to issuance of the OM dated 25% have been finalized by the AG may enlighten about the procedure adopted in this case. As regards pensionary benefit to regularize work search workers, the master roll period of regularized work search workers should also be counted for the purpose of following him her pensionary benefit. It is also worth mentioning that the finance department had later dated 22/2005.
No, all is understood, but how do you take care of 20?
20, my lord, in my lord Prem Singh case, in Prem Singh case, my lord, it is my lord 10 years, my lord, para 30.
Which Prem Singh?
Prem Singh of the Honorable.
Supreme Court?
Yes, my lord.
So then we dismiss, you go to Supreme Court. This I can't give it to you. Now, because of this Sanjita Roy's judgment, this is also attained finally.
Yes.
And more particularly paragraph 31, you have
Yes. No, I have seen that judgment. I
Paragraph
was there.
31?
I was there, Lord. In that case, I was also there.
Okay. Have a
Lordship,
look at
initially-
paragraph 31. Yeah.
Lordship, initially, state government's decision was to deduct the initial 6 years.
Ah.
And count the remaining part.
Ah.
But court said, no, you have to, I mean, take
See the last paragraph, paragraph 31. But the problem is, how do you regularize like this? Anyways, Mr. Sibolwa, you want to obtain instructions?
Yes, right. Good, again, second.
Difficult case to give benefit to the petitioner. Very difficult.
Agent order, maybe bad.
Huh?
Our office might have passed some observation, that is why I want to bring on that record.
Okay, Mr. So-and-so appearing on behalf of the petitioner. On behalf of the Accountant General seeks for some time to obtain the instructions. So taking into account that the person against whom the family pension is being sought for had expired in the year 2003. It is of urgent necessity that the writ petition requires an expeditious disposal. It is of utmost necessity that the writ petition requires an urgent disposal. So list this matter again on 11th of February 2011, or have it later on? 20 February 2026. In the meantime, the reason why the Office of the Accountant General have refused to grant the family pension to the petitioner be disclosed by filing an affidavit on or before 18th of February. What is this?
Item 18. On the petitioner before your lordship, my lord, he was initially appointed as works as field assistant, my lord. In 1981. Finance.
You are still getting provisional pension.
If I have been given regular pension, my lord,
Now-
without pay protection, my lord. That is my grievance, my lord. Under protest, I have received, my lord,
You have given 2000, when did you get?
2025, my lord.
But without?
Without pay protection, because my case is that, my lord, I was all along given pay protection. But pension, they are not giving pay protection, my lord. The amount I should get in as per pay protection, my lord, a little amount, but hardly 1,000 rupees will be more, my lord. That amount they are not giving, my lord. That's why I
But
find
that
the
is
case-
not your case. Because this happened in 2021.
Yes, yes,
2021, your case is that you have got your provisional pension, but you have not been finalized the pension on account of there's a problem with the pay protection.
Yes.
That is not being regularized. Now, they have regularized and given you the final pension.
Regular, for regular pension, but I am eligible, man. More than 28, we have services here, my lord.
Understood. So now you have got it, but you have not got the benefit of the pay protection.
Yes, my lord.
That is your
That is
grievance.
the only grievance, my lord.
Okay. And what do they say?
They say, my lord, that they cannot regularize them because they regularize that particular AG has raised an issue, my lord, that period, my lord, that workers period must be regularized. If I am to get my pay protection pension, my lord. They say this, my lord. But they are saying that they are not going to regularize. Their point is this, my lord, that regulation of workers employee may not be the policy presently, my lord. But my regulation is not like that, my lord, because regulation is for getting regular pay scale, my lord. Because I have got my salary, everything, my, I have got pay protection, they need not pay me salary, my lord. So I am already retired, my lord. Only in my pensions, a little amount is to be given, my lord. For that, my lord, they are saying, well, that has to be regular. In my sample submission, it is why regulation is necessary, I don't know, well, because for regulation, it is always for payment of salary, man. So salary, I am not requiring, man, because I am already retired, man. And they have paid my whatever amount I should get. They have given pay protection all along, man.
Now, have you mentioned it by way of an affidavit about this aspect?
Yes,
About this aspect by way of an affidavit subsequent to getting the regular pension
yes,
done?
yes, I have, well, yes.
Where?
Yes.
Which affidavit?
Yes, you're still fine, madam. Yes, madam. He is 93 perhaps, madam. It's
Eh?
93, madam. If it is in reply, madam, I have 5. It was filed on 25th day of July, madam, 25. And I annexed the pay scale also, madam. What pay scale I was getting for the last time of my regular. That's not quite specific. One of the defects is very against it. And nobody has it. Just number 1.
And what is their stand?
Their stand is that they cannot regularize my road. That is their stand only, madam. My case is that regulation is not similar to my regulation, madam. Because for- for- this affidavit, I am not.
Huh?
I do not have this copy of this affidavit.
Start, my lord, I think what is C.
Others, what he has earlier given.
Okay, okay.
By
Hello. We are getting a pension.
My lord.
Mr. S. Mukhtar, the learned counsel appearing on behalf of the petitioner, submits that though initially the instant writ petition was filed in the year 2021, complaining as regards the non-finalization of the pension on the ground of the pay protection not being granted to the petitioner. Now, on the ground of pay protection granted to the petitioner during the period when the petitioner was in service. But subsequently, in the year 2025, the petitioner received the regular pension as well as the other retirement benefits. But the pay protection which was granted to the petitioner during when he was in service, the same amount have not been taken into consideration while finalizing the pension of the petitioner. He therefore submits that this very aspect of the matter has been brought on record by filing an affidavit on 29/7/2025. Full stop. The council is appearing on behalf of both the state as well as the accountant general shall apprise this court on the next date as to why the petitioner should not be granted the benefit of the pay protection which was given to the petitioner during the time when the petitioner in service while finalizing his pension. Full stop. List this matter again on 4th of May 2026. In the meantime, affidavits be filed by the state as well as the accountant general in response to the query so made by this court on or before 27th of April 2026. In 19 lordships, I need some accommodation, my lord. I have received that record, lordship. Matter pertains to? My lord, that dismissal from service, my lord. You have filed your affidavit? Affidavit could not be filed, lordship, my lord, as because, my lord, that records got for, my lord. You don't want to file affidavit? Lord, record is with me that I. Would you like to file affidavit or not? Lordship, I want to file an affidavit. The instant writ petition has been filed challenging the dismissal order whereby challenging the notification dated 2/9/2019, whereby the petitioner was dismissed from service. Full stop. The records do not reveal that the respondents have filed any affidavit, though the writ petition is of the year 2022. Full stop. Mr. J. Hendek, however, submits that the records are available, records of the disciplinary proceedings are available with him. Mr. J. Hendek further submits that he would be filing an affidavit within 2 weeks. List this matter on 7th of May 2026. The affidavit be filed on or before 27th of April 2026. Liberty given to the petitioner to file the reply on or before 6th of May 2026. On the next date, that is on 7th of May 2026, the instant writ petition would be taken up for final disposal. Full stop. The respondents shall ensure that the records of the departmental proceedings are available on the next date. Liberty given to the petitioner to mention the matter for upgrading.
Obligation.
May I please the lordship?
Writ appeals pending.
No.
Already
Has been disposed of, my lord.
Okay, what is your case?
My lord, my case is dead, my lord.
This one.
Yes, my lord.
When did your father die?
And my lord, Chief Honorable Court at Annexure 3, page 22, my lord,
Forget about that. When did your father die?
in the year 2013, my lord.
Dismissed. The other one,
In the year
What, in 2013?
both dismissed. Hey, dismiss for you. Dismiss.
But they are the direction by this honorable court in the year 2022, and thereafter on this ground, my lord, they have.
Mr. You see, 2013, 13 years thereafter, I can't issue a writ to consider your case for air. You withdraw, we follow with those government, they may do so, but not me. I passed many judgments on that. In fact, on that basis, I was the person who challenged, who set aside 1/6/2015 clause 1. The matter went to the division bench. The division bench, and in 1/6/2015, when I challenged it, I not only asked that, set aside it, but also directed consideration. The matter went to the division bench out there. The division bench also did not interfere with that aspect of the matter. However, put also to notice the counsel appearing and the private respondents therein, they look here, don't have any hope. Isn't it? So hope, I think now is finished. You could survive for 12 years, fantastic. It be Purkash very recently already dismissed. So next. Give your names, whoever it is appearing for whom. Yes, what is this? Mr. Oloskor, where is he? Oh yes, Mr. Counsel. What is your maze? What you are challenging?
Component of salary.
What?
From 2019, they are not paid in salary. And number 1 to 4 are already retired.
I'm appearing for respondent number 1, Your Lordship.
Who is it?
Dibrugarh Development Authority.
The petitioner are employees of the respondent number 1. And the respondent number 1 admitted my placement.
Admitted?
Yes,
Admitted.
In the affidavit in opposition side. The only plea they are taking is that.
Where?
Financial consequence.
Page?
Page.
Huh? In which
96.
paragraph they are admitting?
Paragraph 7H onwards.
Page?
96.
Where they are admitting?
96, 97.
Paragraph 8.
No, where they have admitted that you are entitled to the salaries? Entitled?
Entitled, Your Honor.
Why you are not paying?
Because of monetary issue, Your Honor, the
Financial constraints.
financial constraints are
You
there.
have appointed them, you have taken their service.
The petitioner is still working.
Mohorar. Then
The petitioner number 6 to 15 have been paying since August 2023, but the arrears
2
are
months only pay. Area 2 months were paid. Then on 12/10/2023.
then you close down. Why you are having it? What are you doing? You have no business. Any work?
no,
Is the Dibrugarh Development Authority doing anything?
not properly.
Is the state a party?
Yes.
Yes, state, what are you doing? Finance? What is the standard? Finance, how do you take care of this situation? This Dibrugarh Development Authority have employed these persons,
Yes.
have not paid,
Lordship.
admittedly.
Development authority, this is.
Now, what to do?
Now, if Lordship, look at the affidavit Lordship filed by the respondent number 1, Lordship.
They admit it.
If Lordship comes.
And the amount is huge. 3
Yes.
crores, 23 lakhs.
No, a stand has been taken that they being a statutory authority, Lordship. It is their responsibility to pay their own employees, Lordship. That is the.
Paragraph 7.
Yes, Lordship.
Said this at paragraph 7, because it is,
Oh,
say respond number 1.
understood. But how is the respond number 1 functioning? don't you give grants to the respondent number one?
Yes, we give them grant in aid, Lordship.
Then,
Grant.
have
in-
you asked for that? Money from the finance? Huh? Who are you? I didn't see you are engaged by somebody, you have a senior. Who is your senior?
From the Dibrugarh, he is from Subrata Burman, S. Burman. He's,
So we need to go to Dibrugarh?
no, he will
Then-
give the instructions.
Get him, ask him to obtain instructions. He cannot escape with that.
The last day, madam was left down in view of the absence of the.
No. Then we ask that, who is this? You have a chairman or what? Ask him to appear.
Chairman, Lordship.
We ask the chairman to appear. Well, the chairman is not a party also.
Yes.
Chairman one.
One.
Respondent number one.
This Dibrugarh Development Authority is under how it is constituted? It is like the GMDA.
Yes, it's like GMDA, Lordship, in every.
Country planning act, under the town and country planning act.
Town and planning,
Yeah.
counter planning.
Town and country planning. The government is actually part of the authority.
Government.
Yes. Director of town and country planning is ex officio in person. They are also holding office there.
This court fixes the matter again on 11th of May 2026. Full stop. Taking into account that the respondent number one have duly admitted that the petitioners are herein are entitled to their areas of salary. This court directs both the urban and what is that? The
Housing and Urban Development.
the finance department as well as the director town and country planning. Where's the urban department? The commissioner and secretary to the government of Assam in the Department of Housing and Urban Affairs to bring on record their stand as to how the areas to which the petitioners are entitled to can be liquidated. List this matter under the affidavits be filed on or before 6th of May 2026.
Please. But I'm praying for regularization.
NIT?
Please.
What is this NIT business? What case is this?
I've been employed as an engineer with NIT.
Huh?
I had been employed as an engineer.
Then what happened?
But there was a newspaper advertisement, Millet. Pursuant to that, selection committee selected me as junior engineer, Millet. Page 19 of the writ petition.
Why you are challenging the advertisement?
Advertisement now, prayer one has become infectious.
Good.
I must admit. But the remaining prayers, Millet, they are before this order.
Why?
I'm praying for regularization, Millet.
Why?
On date, but I have rendered 16 years of service with artificial breaks, Millet, before the respondent. Millet,
What in what status?
Millet, as a junior engineer, assistant engineer, and as an engineer, Millet. Today also, Millet, I am in service.
And what do they say?
Millet, they only say that you are contractual. We cannot make you permanent. You had agreed to the same. That is what.
How were you appointed?
Let me kindly have page 19 of the writ petition.
You were appointed on 6 months basis.
Please, Millet, 14th October 2009. Very clearly says Mr. So-and-so is hereby appointed as junior engineer civil on contractual basis in this institute for a period of 6 months with effect from date of joining the institute on the basis of the recommendation of the selection committee, Millet, meeting held on so-and-so. There was a newspaper advertisement, Millet, and pursuant to that newspaper advertisement, Millet, selection committee met, and after an interview, Millet, I was appointed as a junior engineer.
Then
Thereafter, Millet, I have
So
continue.
did you participate in any of the selections
This
which were held?
Annexure A7 minutes. Sorry,
Why you have challenged some advertisement?
please.
Did
Is
you
that-
participate in that?
Participated in that minute.
But you failed.
Success. I did not succeed. I failed.
Then,
For a minute. Despite that minute.
then what right you
I
have?
have a case minute.
You don't have a case.
NIT minute, if they come, because they.
Bad case, bad case. You don't have a case because once you have participated out there,
I shall-
means then a person will keep on regularizing only. There will be no fresh talents.
If Millard
You
allows
have no
me,
right.
Millard, I shall try to convince Millard, there is a division bench judgment of Honorable Delhi High Court. For persuasive value, Millard, I shall place it before Millard and argue Millard whenever Millard gives me time to argue.
Chalo. None has appeared on behalf of the NIT. And what is that NIT full form?
Millard,
National Institute of Technology, Silchar, when the matter is taken up. Considering the above, the matter stands adjourned to be listed on 15th of May 2026. So it is observed that in the circumstance if on the next date the NIT, the National Institute of Technology is not represented, this court would have to dispose of the instant writ petition in the absence, list accordingly.
One more, Millard. I come from outside, so I may be allowed to mention for upgradation on the same date. If that is. I'll be highly obliged.
Liberty given to the petitioner to mention the matter for upgrading.
I'm highly obliged.
Yes, what is this? None appears on behalf of the petitioner on call. Full stop. PWD. Where is Mr. Ardhar? He has been taking time all along, but not filing the affidavit. Okay. The respondent PWD have also not filed an affidavit, nor Mr. Ardhar, whose name appears, who have been seeking time on behalf of the PWD department, have not is present. Considering the above, for the interest of justice, the matter stands adjourned to be listed again on 13th of May 2026. A copy of this order be transmitted to the Chief Engineer PWD for doing the needful. Mr. N. Sarkar, what is it?
Family pension maker. The petitioner husband was my lord working initially as a my lord works as Alashi, my lord.
Oh, it's Bijoy Hapila.
Your lordship.
That day one matter came up, na? When is it?
12th of February.
13.
12th?
12th.
You sure?
I heard it around 13, my lord, on that.
13th. When was the matter?
Yes.
When was the matter listed? Last time?
My lord, on my lord, 27 January.
27 January. What was the name of the case?
Sadhan Hojai. Sadhan Hojai.
I look 27 January list.
6180. 6180.
6180.
Then my lord.
12th February.
List this matter along with WPC number
6180 of 2024, man.
6180
180
oblique
4.
24 on 12/2/2012, not 2
12.
2026.
Lovely.
That is the Bijon Hafila case.
One meter, I don't know, one also. 26.
May I please? The present petition before your lord, Retria executive engineer. And included order says 219. By the included order, lordship, the
monthly pension of the petitioner permanently stopped.
What is the penalty imposed?
My monthly pension permanently stopped. Lordship.
It's a penalty of monthly pension has been stopped permanently under 21B.
Yes.
Why?
Basically, Lordship, we have challenged this, filed this petition basically on two grounds. First ground, Lordship, the second inquiry. is
Affidavit
not-
filed, reply filed.
Yes, yes,
Okay, you have retired?
yes, Lordship.
Fantastic. Who's the petitioner herein is aggrieved by the imposition of penalty under Rule 21B of the Assam Services bracket Pension Rules 1969, whereby his monthly pension have been stopped permanently. The petitioner retired on
2021.
28/2/2021. And Mr. A.T. Sarkar, the learned counsel appearing on behalf of the petitioner, submits that the matter requires an urgent and expeditious disposal, taking into account that the petitioner herein has no pension, has to survive without any pension. Full stop. List this matter on 19th of March 2026 at 2 p.m. Full stop. The respondents shall bring on record the records of the shall produce the records of the departmental proceedings on the said date. Full stop. An attempt shall be made to dispose of the writ petition on the said date. Full stop. 2 p.m. Hard or appeals for and therefore service incomplete. What is this?
The petitioner was retired on 31st July 2020. Since that he has not received his leave engagement benefit and gratuity benefit completely.
Yes.
My lord, I appear for respondent number 1, but I have now instruction to appear for respondent 2 and 3. 2, 3 and 4. My lord will grant me some time because 2, 3 and 4 is the main respondent who has to take a call, my lord, on this. They were the employees of this, my lord, AGMC, Assam Government Marketing Corporation Limited, my lord.
So when are you filing?
My lord, 10 days time, whatever, I will file my return, my lord.
Huh?
In 10 days time.
Because on 18/12/2025, Mr. Ardhar submitted appeals for all respondents and therefore service is complete.
My lord.
So more than 1 month has gone.
My lord, I have talked to the MD also. So my
He has
lord,
not got his say, so we impose interest. So it is seen that though the respondents have duly represented as far back as on 18/12/2025, but no affidavit has been filed. It has been submitted that a final opportunity be granted to the respondents to bring on record their stand by filing their affidavits. Full stop. The counsel appearing on behalf of the petitioner submits that the petitioner have not been fully paid all the retirement benefits and expresses urgency. Lists this matter again on 17th of March 2026. Affidavit to final opportunity is given to the respondents to bring on record and file the affidavit on or before 6th of March 2026. It is observed that if no affidavit is filed, this court shall construe that the respondents have no objection to the relief sought for, and on the basis and by applying the doctrine of non-traverse, the instant writ petition shall be disposed of.
my lord.
28
Actually, my lord, government, they are working on it. There is some
Very good.
deposit and all, my lord. That is what actually. it was.
Very good. HRMS, what is your case?
Removal from service, my lord.
Huh?
Removal from service, my lord, case 63.
Dismissal?
From service.
When?
It is 2016.
Husband of the prisoner was dismissed from service, my lord. Now wife has come, my lord. Husband already died, my lord. in the meantime.
How many husbands?
One.
One petitioner?
Yes, ma'am.
Chalo.
Case 63 is the.
One petitioner died. He died.
My lord.
Now you want the setting aside for the purpose of pensionary benefits. Notice was issued on 4/8/2025. No affidavit filed.
Lordship, some time is required, Lordship.
Why?
Lordship, some time is
5
required.
months have gone.
Lordship, I will file the affidavit, Lord.
When?
2 weeks, more time is required, Lordship.
Oh, well. What is it? The wife of the petitioner herein is the wife of the delinquent employee who have been dismissed from service. And as the delinquent employee had expired, thereby depriving the petitioner of the various pensionary benefits. The petitioner have assailed the inquiry report dated 17/10/2015 as well as the order dated 4/1/2016 by filing the instant writ petition. This court had issued notice as far back as on 4/8/2025, but the respondents have not filed their affidavit. Considering the above, let this matter be again listed on 23rd of March 2026. In the meantime, the respondents are given the last opportunity to file their affidavits on or before 16th of March 2026. On the next date, the
16 March, no?
respondents shall
16 March will file.
also keep the records pertaining to the disciplinary proceedings so that an attempt can be made to dispose of the writ petition. This court also, the above directions so passed shall be without prejudice. To the plea of delay and laches which the respondents can raise in the instant proceedings, inasmuch as the impugn order has been passed, impugn inquiry report is a decade back.
But 59.
Nothing, Your Lordship. The petitioner subject to a departmental proceeding, Your Lordship. And was awarded the punishment of misdemeanor. Therefore, my lord, he has submitted several representations to release his area salary and other benefit measures. But they replied.
Yes, why are you not filing affidavit?
Lordship, I will file, Lordship.
When?
Lordship, 2 weeks.
The petitioner herein was dismissed from service by an order dated 19/4/2024. The grievance of the petitioner herein is that the respondents have not released the balance salary with effect from September 2022 to 17/6/2023, as well as other benefits. This court had issued notice as far back as on 19/12/2025. However, no affidavit has been filed by the respondents. Considering the above, let's this matter again on 11th of May 2026. A final opportunity is given to the respondents to bring on record their stand by filing the affidavits on or before 4th of May 2026. Pending the next date, it shall, however, not be a bar on the part of the respondents to release the entitlement of the petitioner, if so permissible under law.
11.
Well, my instructions are awaited. I pray for some time, madam.
Instructions awaited. Mr. B. Das, appearing on behalf of the petition respondent, submits that the instructions are awaited. Full stop. This is for regularization.
Yes, my lord, as well as my lord, enhancement of their payment.
Is it something to do with that other matter that day we took, where there is a speaking order that these people are not there?
Yes, ma'am. That speaking order has been challenged in this writ petition, ma'am.
When? No,
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 no.
not
That
this one,
day,
the-
another speaking order is there,
Yes,
na? Okay. Could not produce content. They're the same thing, same
Yes,
thing.
madam.
Same thing. Okay. None appears on behalf of the petitioner. Full stop. Mr. B. Das, the learned standing counsel of the APDCL, seeks for a further accommodation to bring on record the stand by filing affidavit. Lists this matter on 29th of May 2026. The final opportunity is given to the respondent APDCL to bring on record their stand by filing their affidavits on or before 18th of May 2026.
My lord, in this matter, I need some time, my lord. Actually, the authorities are examining the case of the petitioner. Probably there will be a favorable decision in favor of the petitioner, but I need some time. So it may be taken up in the next.
Mr. Bora, whatever favorable thing you are saying brings a smile to Madam
Yes, my
SB
lord. Yes, my lord. Because probably due to oversight, he has been
Not looked into, na?
Yes.
Okay. Mr. DP Bora, appearing on behalf of the Health and Family Welfare Department of the Government of Assam, submits that some more time is required for obtaining the instructions, inasmuch as the authorities are looking into it as to whether the petitioner are considering the case of the petitioner. In that view of the matter, list this matter again on 23rd February?
Yes, my lord.
23rd February 2026. On which date Mr. DP Bora, the learned standing counsel, shall provide the instruction as sought for in the paragraph number 7 of the order dated 27/1/2026.
Bless my lord.
Yes, Mr. Dekar.
Case of non-payment of my retirement dues, my lord. 3 to 4 weeks time is required, my lord, to disburse the amount, my lord.
Huh?
3 to 4 weeks is required, my lord.
Retired on 31/10, my lord. In fact, I was promoted, my lord, that.
You have not received anything?
No.
And notice was issued as far back as on 14/5. No instructions? Okay. Who is the managing director of this board? The chairman? A final opportunity. Else we see the face of the chairman. Video conferencing. The petitioner herein is aggrieved by the non-finalization of his retirement benefits by the respondents. Full stop. The materials on record shows that the petitioner retired as far back as on 31/10/2023. Until date, even after a passage of more than 2 years, the petitioner have not received his retirement benefits, her benefits. This court issued notice on 14/5/2025 which is also 7 months, more than 7 months, which is 7 months, 9 months from today. But till date, no instructions have been provided to the standing council. The standing council,
I'm appearing on behalf of PK Munir. He is the standing counsel.
are you standing council or nobody?
I'm not the standing counsel. I'm appearing on behalf of PK Munir. He is the standing counsel.
Has Mr. PK Munir been provided instruction or not?
Yes, my lord. On instruction, I'm appearing.
Has he been provided instructions by the Assam Khadi board or
Yes, my
not?
lord. Yes, yes, my lord.
Provided.
Yes. What
is the
He
instruction?
has no instruction regarding, he has 3 to 4 weeks time maybe required to disburse the amount, my lord.
That's the instruction.
That is the instruction.
Where is that?
No written instruction is there, my lord.
On what basis are you saying?
But on instruction received from
Therefore,
my,
when a matter is being taken up, a council representing a council, namely so-and-so, had made a submission that he appears on behalf of the standing council, Mr. P.K. Munir. Nothing could be clearly said as to what instructions has been received by him. It surprises this court that since 14/5/2025, the Assam Khadi Village Industries and Board have not provided instructions, although they have a standing council. Considering the above, list this matter again on 13th of February 2026. On the said date, either instructions be provided to the standing council by the chairman, Assam Khadi Industries, Khadi and Village Industries Board, or the said chairman, Assam Khadi Village and Industries Village Industries Board be present before this court at 10:30 through the video conferencing link to be provided as to on the next date, the instructions which is being sought for is as to why the petitioner have not been paid his retirement benefits. And if not paid yet, when the amount would be liquidated. You provide the video conferencing link. Who is he?
Replacement petition, Lordship. I am working as a peon under the office of the respondent number 6, Lordship. Assistant Commissioner of Taxes, Lordship.
Who are you? You are a petitioner.
I am the applicant, Lordship.
I am the petitioner, Lordship.
Applicant,
Who is he?
He wants to get impleted in my writ petition. Your
Why?
Lordship. Your Lordship, because there is a stay operating in my favor, not to promote anybody without considering me first. Now, he has claimed that he is a graduate and therefore the promotion needs to be initiated and then he wants to get
The
simply.
petitioner, there is an application filed by the applicant seeking implement to the accompanying writ petition. On the ground that the applicant is affected by the interim order passed by this court dated 27/4/2022. Taking into account the above, it is the opinion of this court that the applicant has a direct interest in respect to the outcome of the writ petition. Accordingly, this court therefore impledes the applicant as the respondent number 7 to the accompanying writ petition. The counsel, Mr. Arsina, who appears on behalf of the petitioner, is directed to file a fresh memo of parties before the registry of this court within 7 days from today. The registry shall make necessary changes in the course title and update the same in the CIS. Icon হৈ গ'ল. Next. Mr. So-and-so, who appears on behalf of the newly impleaded respondent number 7, submits that he would like to file an affidavit. Time is 3 weeks' time is granted to file the affidavit. Pusto. List this matter again on 11th of March 2026.
Deeply obliged.
Read petition of the order. What are any orders? What orders? Lost stuff. Service not taken.
Actually, the official inadvertence.
What?
Previous.
Inadvertent error of a 2016 matter.
So you have taken steps in the year 2024 for a second.
And then no, I think, yeah.
Previous-
First of all, why you are making so many people a party?
They were back in the year 2016 itself, they were made parties.
You got an interim order.
No, there's no interim, just outcome of.
So you have not served them.
Initially, at that time itself, we took steps. Then in the year 24 also we took. But after that, still some have not notice, have not returned after service.
Yeah.
We have sought subsequent fresh instruction, but has not come actually.
Why should we do? You have not got even an interim order. After 10 years, this court, do you expect after not taking service, this court to hear? I think we should dismiss your petition.
It was subject to outcome of the repetition. Observation was made back in the year.
Understood, but these people, they don't know. They must have constructed a house, taken a loan. And now you have not taken a service.
Takes steps, Lordship, 2 times.
No. These people must have already got promoted, transferred, all this place. Where? These people have been appointed as what? Forest.
Forester, Lordship. One of the respondents have
Where is
already
forest?
served.
No forest.
But in rest of the respondent, Lordship, we have sought fresh instruction, Lordship, for proper settlement.
Yet for us, 19-2 order reflects that we are noted. The petitioner had not taken steps. In spite of. The directions issued by the learned laws in the court from time to time. Under such circumstances, this court fixes this matter again on 9th of February 2026. A final opportunity is given to the petitioner to take steps on or before the next date upon the respondent number 17 to 156.
Not together, Lordship, there are separate respondents.
17 to 156. Failing which, this court shall pass appropriate orders.
Well,
But your case, I think we should dismiss. এই ফাইলটো তেনেকে এনেকে লগাই পঢ়িবলৈ নোৱাৰি, what is the problem with these people? What is this? How do you read it? Yes, what is this?
My lord, the lordship may please kindly permit me to be heard the matter. I want to
Withdraw?
make some submission, my lord.
What is your prayer?
It's my lord, I have taken step, but the last, they have only most of them. The notice was issued by care of Director of Employment Action. All the respondents except this 5 who are also employees of that office received the notice. they have not received. It is a matter of restoring my lord, because in the name of the same director,
You retired in 2017.
yes, my lord.
Now what it means? What do you
My
want
lord,
here?
When the matter was taken to the court, he was in service, my lord.
To admit the rule
Because
issued
this is my
and
lord.
directing to immediately make promotion order as to under in respect to the petitioner by restoring the seniority of the petitioner and so retrospective effect.
Lordship, may kindly see the office note, my lord. Office note dated 29/1. Office note
2711.
29/1/26.
No information regarding correct address of the respondent number 6, 7, 8, and 9 has been by the section till date.
And my lodge in my court order dated 27/11/2025.
I must please to permit 4 weeks to complete the process of the where the petitioner has not taken any steps for service of notice upon the aforesaid dispute. Means the
My lord, I want to submit one thing, my lord.
don't submit your, I
There
think
is
your
order.
petition should be
There is
dismissed.
order of the division bench of High Court, my lord. The union instructors who have completed 10 years of continuous service, they have the provisions for automatic promotion, automatic. After completion of 10 years, this is the order of the
That is one decade ago this has happened. You have retired.
But my lord, before retirement,
What do you want now?
I want to be heard, my lord. Yes,
In absence of respondent number 6 to 9.
No, not regarding entire case, my lord, because
How on earth can I hear you without the respondent number 6 to 9 being served?
actually, my lord, they are the example. I have given them as the PCC.
So we strike out the respondent number 6 to 9. Mr. Counsel, let us strike out the respondent number 6 to 9.
No, my lord.
No, Mr. Decker, kindly listen. If you want the respondent number 6 to 9, you have to take service steps. If you don't want, we strike off, then we proceed.
No, okay.
Strike out?
Yeah.
Huh?
Okay, strike out.
Okay. The counsel appearing on behalf of the petitioner submits that the respondent number 6 to 9 may be struck off. Taking into account the above, the respondent number 6 to 9, the names of the respondent number 6 to 9 are struck off. Full. Taking into account the above, comma, the service therefore is complete. List this matter again on 18th of February 2026 for admission.
No.
Enterprise the official pay the 10/12/2023.
Resume service. Okay. This court taking into account the service office note dated 10/12/2025 resume service as regards the respondent number 5 and 6. Accordingly, the service upon all the respondents are complete. List the matter for admission on 20/2/2026.
Bye.
Please, your lordship, in this case, lordship, area.
He has got the money, no?
Yes, lordship, I have received the authority also.
Okay, today it is a very unusual. I got an email from Mr. B.C. Das. He's not well, so he said that matter can be disposed of, taking into account. It's some 2,71,000.
Yes, lordship.
Very good.
Petition.
It has been submitted that the petitioner have got the relief as has been sought for by way of the present writ petition. Mr. R.K. Talukdar, the learned counsel appearing on behalf of the Accountant General's Office, have also placed before this court a communication dated 29/11/2021, whereby the amount of rupees 2,71,271 have been sanctioned. The said communication is kept on record and marked with the letter X. Taking into account the above, the instant writ petition therefore stands closed, as the grievance of the petitioner have been redressed. Yeah, what BC does senior advocate deputy.
Six.
Please, Lordship. In this case, expense number 11 is headed.
Okay.
NHM. We have some copy also. Otherwise, also service is complete.
Service complete. This is the matter for admission when urgency, no urgency. What is the urgency?
This challenge has been made to the appointment of restaurant number 9 as Asha worker.
Asa worker
It's 23.
on 18th of February 2026 for admission.
For office number 24/11/25, I'm sorry, Lucy, I'm not. I've taken steps. for the
What?
time, but it's-
Matter has been dismissed for default.
Yes, sir.
Huh?
Yes.
Why? Where is the order of dismissal? None appears for the, none has appeared on behalf of that being so, this court dismissed for Anupada Standing Council Irrigation Department. Why? What is the ground?
God is what's it, and then there are six.
Huh?
There are six of the INA. Five.
What?
So the, I guess, because it is from the other court, so it's not.
Who is the other side? Anupada. He's not here, na?
Yes.
What do I do?
I'm appearing for respondent.
Oh, you are appearing?
Yes, Your Honor.
So we restore it.
Yes.
There is an application filed for restoration of the, for recalling of the order dated 18/4/2022, passed in WPC number 4273 of League 2017, whereby the writ petition was dismissed for non-prosecution. This court have duly perused the reasons which have been assigned in the instant application and is of the opinion that this is a fit case for restoration of the accompanying writ petition. Mr. So-and-so appears on behalf of the irrigation department and also does not object. Considering the above, the writ petition therefore stands, the order dated 18/4/2022, passed in WPC number 4273 of League 2017, stands recalled. The writ petition is restored to the file of this court. The interlocutory application stands allowed. Pusto, ekhonot dibo. Main writ petition ko dibo. List this matter for admission on eleventh of February 2026.
Deeply.
What is this?
Your Lordship peruses the last order, Your Lordship. 18th of December 2025.
Yes, Mr. Nath,
Take your time.
you are requested by this court in this matter.
Take your time.
Well, here, the state has preferred an appeal against the judgment. Against the judgment dated 31/2023, my lord. That appeal has been dismissed on 12/12/2025, my lord. And after that,
What is the direction passed?
Lordship, here, there is a clause in the OM of the compassionate appointment. The clause says that the minimum of 3 years service should be there to consider the case of the petitioner. Lordship has set aside that particular clause and directed the respondents to consider without taking a note of that particular 3 year service minimum requirement. Against that, my lord, the state has preferred an appeal. That appeal has been dismissed, my lord, on 12/12/2025. It is dismissed now. The authorities, we have already sent it to the authority, my lord, and they are in the process, my lord. The SLC or the respective DLC, they will help, my lord. Some time may be given, my lord. I have talked to them, my lord. The respective DLC and SLC already whatever was pending, those were considered, but this particular clause, the matters which are covered by this, these are, my lord, only in the process, my lord. These are not been.
You will have a relook.
They will have to, my lord. They will.
Okay. taking into account that the division bench of this court have passed the judgment only on
12/12/25.
12/12/2025. Let these matters be again listed on 8th of April 2026. And it has to go after that, no? Taking into account the model code of conduct, all these things
this
will
is
come in
there, Madam.
on 13th of May 2026.
Madam.
Obliged, Your Lordship.
Copy of my video. Extra copy of video.
Yes, what is this? Huh?
Your Lordship, the petitioner was supposed to be granted the minimum of the pay scale.
You
So-
gave it?
No, Lordship, there was initially the proposal which was sent, there were two appointment dates, Lordship. So the
Ah.
department had sought for clarification. That clarification was given to the department on 29th of January 2026, Lordship.
Ah.
Now we have placed the proposal in the screening, yes. The screening committee, the proposal will be placed in front of the screening committee shortly, Lordship.
Ah.
And Lordship, for some time may be given, Lordship.
Okay. This order was passed so long back.
Yeah, Lordship, the clarification was received on 29th of January, Lordship, of this month, of this year.
List these matters again on 9th of March 2026 for an update.
Lordship.
Bye. From September 10, my lord, the respondent taking time in the name of filing the appeal, my lord. I inquired, my lord, the appeal is under objection from
My lord,
26/9/2025,
I have,
my lord.
my lord, I have made a mention of the appeal and the honorable division bench has, my,
Status of the appeal, my lord.
my mention has been allowed, my lord, to be listed on day after tomorrow, on Wednesday.
This one,
Against this order, my lord.
an appeal is pending.
My lord, we have preferred the appeal, we have made the mention, and honorable court has allowed to list it on Wednesday. But I pray for some time, my lord, kindly give me some time.
It has been submitted and an appeal has been filed against the order dated judgment and or dated 25/6/2024, passed in WPC number 367/2022, which is to be listed again before the learned division bench of this court on 4th, na?
Fourth.
4th.
I have made a mention, it will be listed on fourth.
4th.
For the
Was
first-
taking
for
into
the first
account the
time-
above, list this matter again on 23rd of February 2026 for an update.
Again, this is a compassionate appointment.
You have not filed the IA.
My lord, we have filed, my lords. That is for the correction of the name of the private respondent, my lord.
Then why haven't you filed? That is why the matter is listed.
Yes, my lord, we have filed, but it is lying in the defective
Okay.
section, my lord.
It has been submitted by Mr. Bora, the learned counsel, appearing on behalf of the petitioner that an interlocutory application has been filed. However, the same is in the defective. The number of the said application is so and so. The registry shall verify the said aspect and thereupon list the interlocutory application along with the instant with petition.
Number is, my lord, 6926, my lord.
Seven. In this case, my respondent of five,
Oh, this one.
fix this matter for disposal from other day.
We dispose it of on the next date. List this matter on 5th of March 2026 at 2 p.m. for disposal.
Lordship, here, order review arises from a common order dated 25/2025. So we have already filed 9 review petitions. 2 have been listed, Lordship.
All are Gayatri distillery.
Yes, Lordship.
Huh?
Lordship on the last occasion, directed to list it on today along with the others, but I have the numbers, Lordship.
Okay, list this matter along with so and so. On, we have to issue notice, na?
Yes.
On, who was the counsel who represented Gayatri?
Lordship, G. Rahul, Gautam Rahul,
Huh?
Gautam Rahul, Lordship.
Gautam Rahul, okay. You give a copy? Have you given a copy?
Lordship, there was no caveat and.
Not necessary, it's a review.
Lordship, I will give him.
So
copy.
Mr. B. Chaudhary, appearing as standing counsel of the Finance and Taxation Department, submits that. Oh, this is pertaining to the refund one.
Yes, refund of the pre-deposit.
What is wrong with it?
While processing it, Lordship, we found that the document that they produced before the revisional authority, that the licensing of a particular dealer has not expired and it was still in continuance. Subsequently, we verified that letter was not issued by the authority of Arunachal Pradesh. They have specifically given a communication that the number they have, memo number that has been shown in the letter is completely different on that particular bill.
Mr. B. Chaudhary, is the standing counsel appearing on behalf of the Finance and Taxation Department, submits that along with the instant review application, how many applications?
Another 7.
Another 7 applications have been filed, which are numbered as so and so. Full stop. He therefore submits that all these review applications be taken up together. Full stop. List his matters again on 5th of March 12th of March 2026. Full stop. The counsel for the petitioner, the review applicant is directed to also submit submit advance copies to Mr. G. Rahul, the counsel who represented the petitioner, that is MS Gayatri Distilleries and Bottling Industries Limited. On or before 27th of February 2026. Medul Kumar lost call. Oh, this one. Okay, list this matter again on 11th of May 2026. At the senior of the council is not present. What is this review? Service complete.
Not complete, ID card awaiting.
Unserved notice has been received back where insufficient address and kept. Who was the council who was representing? Rajkumar Sinha. Why the review has been filed?
Let's see, the earlier order dated 17 March 2025. More particularly page 19, proceed, of the order. In para 6, it is seen that the said claim proceedings was filed in the year 2011. In the said claim proceeding, the claimant did not file any document which would show that there was a regular accident. Such and such. But see, actually documents were filed in the claim proceeding.
The results assigned by the learner. So what is there to interfere?
Lord, see, these documents were filed there along with the claim proceedings. And your Lord,
Where?
we have annexed in the review petition.
You did not appear.
Lord, see, that is my case, Lord, see, because case is such kind of a different kind of nature, Lord, see, because earlier counsel is cleared the petitioner on several occasions.
What?
Because he did not then inform her about filing of the MSc case
Who?
earlier against counsel.
No. I think
But-
we should dismiss it.
No, Lordship, but this.
No case.
Then it is still.
Sorry. We dismiss now.
Because we have.
Ekon.
We have filed.
Yeah.
the-
So it is seen that the service upon the respondent number 4 is not complete. The petitioner is directed to take fresh steps upon the respondent by way of speed post within 3 days. After that, I'll dismiss. Don't have a case.
As per last office note, service completed.
Service complete. The service being complete lists the matter for admission on 18th of February 2026. Shortage of postal stamp.
Statement, yes, what is the 5 rupees, I may be allowed.
Then?
3 is personal spender.
Then?
The copies are up 1 to 9 given, my lord. Only the 10 to 13, my lord. Mistakenly, the 5 rupees is short. my lord. I'm sorry.
You have not paid it, and why should we engage? You are paying for.
I am appearing for the respondent number 13, the complainant.
What is your respondent number?
13, Lordship. Today,
13.
I have filed the Wakalatnama.
Okay.
Lordship, just one prayer, I may be furnished a copy of the petition, Lordship.
Yes,
Okay. What about the others?
my lord, 10 to 12, my lord, I have to take steps, my lord. 5 rupees to get it, perhaps, for the purpose. 1 to 9 is, my lord.
Why should we extend when you are not paying 5 rupees?
No, my lord, I do not do the, my lord, by reading the office note, my lord. We are not aware of. We are not aware of that, that happened. 5 rupees short. We are not informed, my lord. This is
Mr.
sufficient.
Council, we also know why 5 rupees less is paid.
No, my lord, that is not the exit, my lord. All of the steps taken, my lord.
Suffer?
Main persons are given copy, my lord, immediately.
Consequential inquiry that is order dated as well as they are which have been undertaken as. What is the case about?
My lord, regarding, my lord, the departmental proceeding on sexual harassment in the workplace, the suspension, I was suspended and department proceeding was started. Suspension is.
Who are respond number 10 to 12?
My lord, the inquiry officer. Inquiry officer and presenting officer.
Why? You are alleging something against them.
My lord, my lord, there are 3 inquiries going on at a time, my lord. That's why, my lord, as per law, they cannot run at a time, they're running under the same.
You are appearing?
Party.
I am appearing for the complainant.
Complainant.
Okay. List this matter again on. Mr. So-and-so appears on behalf of the respondent number 13 and submits that a copy of the petition be provided to him.
Yes, Lord.
In as much as the service had not been effected to the petitioner upon him. Considering the above, the counsel for the petitioner is directed to serve an extra copy of the petition during the course of the day. It is also seen that the service upon the respondent number 10 to 12 is not complete. And the reason the service could not be effected or is on account of deficient court fee stamps. Deficient stamps. Accordingly, this court fixes this matter again on 11th of March 2026. Liberty given to the respondents to bring on record their stand by filing the affidavits. In addition to that, the petitioner is further directed to effect service upon the respondent numbers 10 to 12 by way of dusty routed through the registry of this court and ensure that the service is meted upon them on or before 16th of February 2026. Full stop. The interim order passed earlier shall continue till then. In addition to that, the petitioner is also directed to supply the deficient court fee stamps so that the respondents, so that the state registry can also take effective steps by way of speed post. Hang on. What hearing? No hearing. What hearing?
Personal appearance was directed in this matter.
Which one?
The
Sir, sir.
18/11/25 order. It's a case of discontinuation. My services were discontinued without following the principles of natural justice. And later on, when the affidavit was filed, it was revealed that it's a case of a stigmatic termination.
18/11/25 order, my lord. Till date, my lord, no report has been furnished as directed, my lord.
Why is it for the hearing it has come?
No, during the course of the hearing, my lord, this information was sought, my lord.
Now, why was the hearing matter is fixed for hearing?
It was fixed for hearing, my lord, during the.
Why? Has it been admitted?
Yes, yes, no, the affidavits and pleadings have been exchanged.
Where is the admission? And these type of matters, you have been, what has happened?
It's a case of a schematic termination, my lord. without-
Termination.
Yes, my lord, without following principles of natural justice.
Okay. We do one thing.
Thursday, my lord.
The petitioner herein is aggrieved by the termination by the order dated 6/12/2023. The petitioner submits, the counsel for the petitioner submits that the termination is stigmatic and as such, and that too without following the due process, following the procedure established by law. He therefore submits that sometime maybe, he therefore submits that the matter requires an urgent disposal. Mr. Gupta, I don't have time. First week, second week, it's third week, I'm not there. Can I have it on 10th March at 2 p.m.?
Suffering, my lord.
Understood, but if you want, I can fix it on any day. On 19th of February 2026. But I can't have it. I can't say anything. But I may not be there for these 2 weeks. So if you want, I can have it on 19. No problem with that.
No,
19?
19.
Oh, on 19 to 2026. Was liberty given to the petitioner to mention the matter for upgrading.